Let me mute myself.
Good afternoon, ladies and gentlemen. This is McCracken Circuit Court. This is Division II sentencing docket. First on the docket is Commonwealth versus Derek W. Dixon. Do we have Logan County Detention Center on jail or online?
Yes, sir.
Okay, thank you very much. And do we have Mr. Dixon there?
Yes.
Okay, thank you.
All right, I represent Mr. Dixon.
Thank you, Mr. Brown. Mr. Brown, have you and Mr. Dixon reviewed the PSI?
Your Honor, I had sent that to the folks at the Logan County Jail. Derek, did you get a chance to look at the PSI report?
Yeah, I looked at it.
Does it look correct to you?
It looks correct.
Okay. Then yes, Your Honor, we find no major errors or omissions. Just have to be heard on probation today.
Yes, sir, Mr. Brown, I'll hear you.
Your Honor, Mr. Dixon does come back as a moderate risk. The felony component of this case is a possession first degree first offense. We would just respectfully ask the court to consider probation and allow him to take advantage of that presumption, Your Honor, so that when he is ultimately released, he would be on supervision with probation and parole. I think he would do well. And Mr. Dixon, would you like to address the court as well?
I would like probation, if that's possible.
Mr. Dixon, what do you have a drug addiction problem?
Yes, sir, I have.
What's your plan to address that?
Please, some kind of substance abuse treatment or MRT or just whatever you tell me to do, sir.
Are you a state inmate now?
No.
How did you wind up, how do you happen to be in the Logan County Detention Center?
I'm going to court over some other charges that haven't been found guilty on.
Because I didn't see any, in Logan County?
Yes.
'Cause I didn't see that in your pre-sentence investigation report. What are you charged with there? And I'm not asking if you did it or not. I'm just asking what you're charged with in Logan County.
Trafficking methamphetamine.
When is that alleged to have occurred?
Was it January, I think, December or January?
All right, Mr. Dixon, you have 5 prior felony convictions, and I can't overlook that. You may be a candidate for shock probation, but as it stands right now, I'm going to have to put you in prison. Court finds you guilty of a DUI first offense, sentences you to 30 days. There's a $425 service fee, alcohol, drug education classes. There's also a license suspension between 30 and 120 days, and I believe now the Department of Transportation decides what kind of license suspension you'll have to have. Court finds you guilty of trafficking in marijuana under 8 ounces first offense and sentences you to 12 months. First degree possession of a controlled substance, methamphetamine, sentences you to 18 months. Failure to produce an insurance card, a $25 fine. Possession of drug paraphernalia, 12 months. I'll run the jail sentences all concurrently for a total of 18 months. Then you'll have the $25 fine on top of that. As I said, the court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because there is a substantial risk that during a period of probation or conditional discharge, the defendant would commit another crime. The defendant is in need of correctional treatment that can be provided most effectively by his commitment to a correctional institution, and the disposition of probation would unduly depreciate the seriousness of the defendant's crime. Court costs and public advocate fee are?
$975.
Thank you. Do you have any money to pay that, Mr. Dixon?
Not right now.
I will waive your court costs and your public advocate fee. There's also an order of forfeiture. Have you seen this, Mr. Brown?
I have not, Your Honor. Is that pertaining
Drugs and
to?
paraphernalia, $291 to be forfeited. And I guess probably when he pled guilty, he agreed to forfeit all items seized.
That's fine.
Yes, Your Honor.
All right. Good luck to you, Mr. Dixon.
Thank you.
And thank you at the Logan County Detention Center for having Mr. Dixon present. Do we have the Fulton County Jail online? We do not, and I believe Tana Engler is at the Fulton County Jail.
Yes, Judge. This is Mr. Reed. I'm here on her behalf. I was told she could be reached by phone, telephonically, but not on video, and that's all I can tell the court at this point. My understanding is she applied to drug court and was accepted, but I don't have any paperwork on that. And I'll be happy to put, if you're going to move this into the docket and call them and get her online telephonically. That's.
Well, I don't know if I want to sentence her telephonically. I think we're probably either going to have to get her back or get Fulton County online.
I understand, Judge.
So we may have to transport her back to McCracken County.
June 24th.
Continue her to June the 24th. And Mr. Reed, we'll have to, I'm going to need your involvement in reminding me that we need to either make sure she's back or be able to get them on the line. We can't keep putting this off, but I'm not going to do it telephonically. I need to be able to.
I understand, Judge, and I'll do, if I have to do a transfer order, I'll do that, or I'll keep on track of it.
I appreciate that, Mr. Reed. Thank you. Okay, and Commonwealth versus Peggy Roberts. I believe she's in Fulton County as well. Who represents Miss Roberts?
John Johnson, and she's in Fulton County.
All right. So, Mr. Johnson, we're either going to have to find a way to get them online. If they don't go online, then we're going to need to transport her back so she can be sentenced.
Okay, she's a state inmate at the moment, Your Honor, but
Okay. So I'll continue hers till June the 24th, but I need you to stay on top of that, please, Mr. Johnson.
okay.
Commonwealth is Kenneth Bledsoe, 20 CR 842. Change my view here.
I found, it's under your computer.
Was closer. We thought we was running late. We thought we could do the females first.
Okay. Okay.
If it's okay with you, Your Honor.
That's fine. Who do you have?
Like in Harned?
I represent Lake and Herndon.
Right.
Thanks. Mr. Johnson, have you and Ms. Harned reviewed the PSI?
I've reviewed it. I have not gone over it with her. It does appear to be correct to me. And I think we're ready for final sentencing.
Very well. Do you wish to make any statements on Ms. Harned's behalf?
Yes, I'd like to ask her a question first. Lakin, we do have an update to the PSI judge. She was final sentenced in Ballard County on May 7th. And my question to her was what happened? It says 3 years suspended, and I think that probably means probated, but I wanted her to clarify what happened last week.
I got probated to a long-term treatment facility.
And do you have one lined up?
Yes. Miss Emily Garrison has one lined up for me.
Your Honor,
Okay.
this is Chuck Walter. If I may interrupt, I was counsel for Ms. Harned in Ballard County, and that is accurate. She was probated to that particular treatment.
Thank you, Mr. Walter.
Do you have a bad date, Lakin?
It's actually one of those things where they put in for Kentucky Center and it's a toss-up. So as soon as I am
So
probated, they have
Kentucky
me.
Recovery Center bed, and you'll get a bed within 2 weeks?
Yes, that is correct.
Okay, that's right. I remember seeing the emails now. So, Your Honor, she has been probated recently in Ballard County. On this case, I noticed she has 159 days applied to this case. And she's been approved for court-ordered supervision in her Ballard County case. And we'd ask that you go along with that and do that in McCracken County as well. If you read her statement, she said that she's sorry and tired, of this lifestyle and the poor choices that she's been making. And I think she has a plan to change that.
Yes, Your Honor.
Okay, thank you, Mr. Johnson. Ms. Harned, would you like to make a statement?
I would. I'm sorry for my previous, mistakes, and I want to change my life. I want to do something different. I'm tired of this lifestyle, and I don't want to do it for anybody else, just for myself. I truly am tired. That's all.
Ms. Harned, the court finds you guilty of receiving stolen property over $500, under $10,000, 2 counts. We'll sentence you to 18 months on each of those counts. Receiving stolen property under $500. Let me look. This is- Okay. Yeah, just the PSI is incorrect. Just want to see if it was their fault or our fault. Finds you guilty of receiving stolen property under $500. I'll sentence you to 12 months. In case 20 CR 552, the court finds you guilty of first-degree bail jumping and sentences you to 18 months. Those will run consecutive to the 18 and the 12, which will run concurrent, for a total of 36 months. Your sentence will be probated for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer. Pay your $30 a month supervision fee. Let's see, you say Ballard County probated you to was it a long-term or residential treatment or what?
Long term.
I don't think an assessment is necessary. I think we all need drug treatment. So I'm also going to order that you complete a long-term treatment. I'm also going to order that you successfully complete moral recognition therapy. You will be randomly drug screened while you're on probation. You'll have to pay for that. You are subject to graduated sanctions by probation and parole. Court costs and public advocate fee are
For both cases, Judge, it's $1,070.
$1,070. We'd be able to pay that in 6 months, do you think?
I'm gonna be in rehab for 6 months, but hopefully it's somewhere I can work. If it's somewhere I can work, I'll make sure it's paid.
I'm going to give you until May the 13th at 10:30, May 13th of 2022. It's a year from tomorrow to have it paid. If it's paid, you don't have to come back to court. If it's not paid, that's when I'm going to see you, May the 13th of 2022 at 10:30 a.m. Don't forget that date, Ms. Harned. Nobody's going to, I don't know if that's going to get written down for you or not, but you're going to have to keep track of that.
I'll write it down, Your Honor.
And if you'll pay that before then, you don't have to worry about coming back to court.
Thank you, Your Honor.
All right, good luck to you, Ms. Harned. All right, who's next?
Casey Harlan.
Casey Harlan. Thanks. Let's see. Over for Mr. Irwin, Ms. Harlan's case.
John Straub.
Thank you, Mr. Straub. Harlan reviewed the PSI.
We have, Your Honor, at the jail.
Any objections, corrections, or additions that need to be made?
Just a correction on page 6, on her criminal history. It shows her Texas case is still pending. She's actually already been probated on that.
Any other corrections?
No, sir.
You wish to make a statement on Ms. Harlan's behalf?
Just briefly, Your Honor, she does have that pending bail jumping, but I imagine we'll get that resolved pretty quick. But her mom, so I guess what I was going to say is if you do probate her today, she's still not getting released, although we are asking for probation because I still think she has a decent shot at probation with the bail jumping that we're going to deal with here in several weeks. Her mom is having a real tough time and it's impacting the rest of her family. Her mom has recently had a stroke and her mom is responsible for caring for her 11-year-old and her 6-year-old while she's incarcerated. And this has just put a strain on everybody, especially her mom's health. And her 6-year-old is a special needs child who is partially blind. So she really wants to do everything she can to get out of jail and be there for her children and just make them a top priority in her life. She's willing to do anything to satisfy the court that she'll remain drug-free. She's expressed to me that she's willing to do an IOP, random drug screens, really just anything the court wants. So additionally, Your Honor, she has her high school diploma and she has 3 years of college. She's told me that 2 more classes and she'll actually have a college degree. So we are asking for probation, please.
What's the status of her bail jumping case, Mr. Straub?
I think she's set for a pretrial conference. Do you know your next court date?
It's June 21st.
Ms. Harlan, do you wish to make a statement?
Yes, Your Honor. I just want to apologize for missing court to get the bail jumping, but I'm really trying to turn my life around. I'm sick of living the way that I was living. My kids need me. My mom needs me. I'm tired of it.
All right, then, Ms. Harlan, the court does find you guilty of, actually, you pled guilty with no recommendation. Is that right?
Yes.
Court finds you guilty of first-degree possession of a controlled substance, methamphetamine, second or greater offense, and possession of drug paraphernalia. For second offense, possession of drug paraphernalia, I will sentence you to 3 years. For possession of drug paraphernalia, I'll sentence you to 12 months. I don't know if I said that right. Things didn't sound right to my head as I said them. For the second offense, methamphetamine, it's 3 years. For the paraphernalia, 12 months. I will run those concurrently for a total of 3 years. It'll be consecutive to any of your other cases. Ms. Harlan, my plan is to probate you, but not until your bail jumping charge is complete. It was going through so right now I'm sending you to prison. You will be eligible for shock probation around the time you complete the bail jumping court. So I will strongly consider you for shock probation then. That's, I'll tell you now, that's what my plan is. I'll shock probate you on this one, and I'll probate your bail jumping charge. But it'll have to be into some treatment facility, I would imagine. But that's kind of what I'm looking at right now. Court costs and public advocate fee.
545.
Do you have money to pay that right now?
No, sir.
All right, I will waive your court costs and your public advocate fee. And I'll see you in June for your pretrial on the bail jumping. Good luck, Ms. Harlan. What's your name, please, ma'am?
Claudia Kramer.
Thank you. Mr. Johnson, you represent Ms. Kramer? And you're muted, Mr. Johnson.
I do. I believe we're ready.
Okay, thank you. Are there any corrections that need to be made to the PSI?
Don't believe so.
Do you wish to make a statement on Ms. Kramer's behalf?
Yes. Let's see. I believe she's a state inmate on case number 20 CR 160. And this is a bail jumping that occurred when she failed to appear for final sentencing on that case on December 18th, last December. She's been incarcerated. My notes here are incorrect. Ms. Kramer, how long have you been in jail?
Since October 26th.
Oh, okay. That was. Just 1 second, Your Honor. I'm a little confused.
right.
Let me look here. So, okay, on June 30th, she had missed sentencing in that case, not back in December, like I said. Okay, so I'm sorry. I had my dates confused here. Anyway, she's been incarcerated 6.5 months. She's a state inmate on the other case. I think we filed for, I'm trying to reconstruct what happened on that other case. In CourtNet, it looks like we filed a chalk motion in January. I'm not sure that that's ever been ruled on, or I'm not sure if it automatically gets ruled on after 60 days or 6 months. I don't know if we need to file another shock motion on that case. What we wanted to do was ask for probation on this case, and if I need to file for shock on the other case, we're prepared to do that. But I think the time that she has served has hopefully been sufficient where she could be given a chance on probation at this point.
She's also a state inmate in Livingston County case, is she not, Mr. Johnson?
Okay. Is that correct, Claudia, on your,
Yes, sir, it is.
okay. Claudia, do you know when you're going to be looked at for parole or anything?
I signed 5 serve out papers.
When do you expect to serve out?
I don't know. Because I was gonna stalk the shock, and I felt like the judge didn't give me probation, that's what I was gonna do.
Okay, well, it looks like you're still eligible for shock in Livingston. I think you're within the 180-day window. And she's asking for a chance on probation.
Ms. Kramer, the court finds you guilty of first-degree bail jumping and sentences you to 18 months. That's consistent with your agreement with the Commonwealth. After reviewing particularly your history, Ms. Kramer, court has determined that it is considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because there's a substantial risk that during a period of probation or conditional discharge, you'd commit another crime. You are in need of correctional treatment that can be provided most effectively by your commitment to a correctional institution and the disposition of probation would unduly depreciate the seriousness of your crime. Court costs and public advocate fees are
$525.
$525. You have any money to pay that, Ms. Kramer?
No, sir.
I will waive your court costs and your public advocate fee. And of course, this sentence will run consecutively to any other sentence that you're serving. Good luck, Ms. Kramer. Who's next?
Aaliyah Moore.
Good afternoon, Your Honor. Kevin Olson on behalf of Ms. Moore.
No. I'm sorry, who's for Ms. Moore?
Kevin Olson, Your Honor.
Thank you, Mr. Olson. I gotta fix this so you pop up.
I'm trying to find the jail on mine, so I'm.
All right, there you are. All right. Mr. Olson, have you and Ms. Moore reviewed the PSI?
We have, Your Honor.
Are there any corrections that need to be made to it?
Judge, there are a couple corrections. Some of them are, yes, Judge. One of the counts that she is showing up as having been convicted of is trafficking in a controlled substance, first degree, first offense, fentanyl, criminal facilitation. Judge, that is all correct, except it was also firearm enhanced. Without the firearm enhancement, that would only be an A misdemeanor. And the agreement was to the D.
Very well.
Judge, as to the rest of the charges, the rest are accurate. Her criminal history is a little bit inaccurate, Judge. In case number 17 CR 121, it is showing that she was convicted of criminal mischief in the first degree, and it is showing a 12-month sentence. Judge, as this court is aware, that would have to be a misdemeanor, and I looked it up on CourtNet. It was, in fact, amended to criminal mischief in the second degree.
Thank you.
Thank you. And Judge, one other issue would now be the jail credit, and you may have a modified one, I'm not sure. But at the time that she was originally set for sentence, she had COVID, so she was unable to appear. She now has, over another month in jail, Judge. So we have her total credit at probably around 150 days.
Right, and that's what I'm showing, even though that I won't make an official determination on that credit, but that's what I show.
Wonderful. Thank you, Judge. As to the rest of it, Judge, I would like to address the court on her behalf. As we can see, this is her first felony conviction. She has been in jail now for roughly 5 months. I'm going to say some stuff that might make her mad at me, but I hope not, because it is true. And the truth is, Judge, when Ms. Moore first hired me, she was very much in the midst of a drug addiction. There is just no question about it. And frankly, was difficult to communicate with for a while. She has been in jail for 5 months, and I think she would agree with that. She has been in jail, and the difference between Ms. Moore now as a clean and sober person versus before is night and day. She is a remarkably nice woman. She is incredibly bright. She has her entire life in front of her. She is a young mother who has acknowledged directly to me on more than one occasion about the importance of getting back and being the mother that she wants to be. If she is clearly guilty of these offenses and has never disagreed with that, she and her co-defendant, who is her boyfriend, she was making bad decisions by staying with him. Judge, the nature of his charges are such that it very well may be that he is going to be in custody for quite some time. What we would ask you to do is to give her an opportunity on probation. I think if you were to order that she have complete MRT, I think that would be useful. I think it would also be useful if you were to order her to have a drug and alcohol assessment. I don't believe alcohol is her issue, and I believe she's clean today, but I also think that she's going to need some help to remain that way. I have no doubt that she can do it. In a lot of ways, she's very impressive. She is a young homeowner. She's a mother. And I think if you give her an opportunity on probation, Judge, I think she can do exceptionally well. So thank you.
Thank you, Mr. Olson. Ms. Moore, do you wish to make a statement?
I do. I would agree with Kevin. I am I do take full responsibilities in my action. I was surrounded by people who influenced bad behavior, and that led me where I am today. It's been a life-changing experience for me, but it's also been an eye-opener. My main priority is just, if I do get probation, I will be filing a motion to get my son back. That's my main priority, and that's what's going to keep me motivated to be clean. And I am a homeowner. I have an experience in factories, so I will be having a job when I do get out. And I have a great support system, which is my grandmother and my son's grandmother, that's where he's placed with. And I just asked if you just give me this opportunity to change my life. Thank you.
Okay, thank you, Ms. Moore. Court finds you guilty of the offense of criminal facilitation to trafficking in a controlled substance, first degree, first offense, fentanyl. Sentence you to 5 years, and that's with a firearm enhancement. Sentence you to 5 years. Possession of marijuana, I'll sentence you to 45 days. Possession of drug paraphernalia, 12 months. First degree wanton endangerment, 5 years, and first degree possession of controlled substance, opiates, sentence you to 3 years. Those will all run concurrent for a total of 5 years. The court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because there is a substantial risk that during a period of probation or conditional discharge, the defendant will commit another crime. The defendant is in need of correctional treatment that can be provided most effectively by her commitment to a correctional institution, and a disposition of probation would unduly depreciate the seriousness of the defendant's crime. Court costs are
$195.
$195. Do you have any money to pay that, Ms. Moore?
If I were to be released, yes.
Okay, but understand you're not going to be released.
Okay.
Okay, so I will waive your court costs.
Thank you, Your Honor.
Good luck, Ms. Moore. Thank you, Mr. Olson.
Thank you.
Is this Mr. Bledsoe?
No, Mr. Riley.
Commonwealth versus Chester A. Riley, 21 CR 4.
Okay. Let me get my file.
Who represents Mr. Riley?
Your Honor,
Ms. Lee?
Audrey Lee. I represent Mr. Riley. Let me find where he is in the order. Okay. Yes, Your Honor, I represent Mr. Riley.
Okay, Ms. Lee, have you and Mr. Riley reviewed the PSI?
I have reviewed the PSI, Your Honor, and I took a copy to the jail to him for review. So if he has any corrections, he can say so. I've looked at it and I really didn't see anything that looked out of order, Your Honor.
Okay, thank you very much. Do you wish to make a statement on Mr. Riley's behalf?
Yeah, Your Honor, yes, I will say this. I took this to the jail. The reason why he's in jail is that he is a current state inmate. He received no credit, on this charge here. This is a 2-year sentence here, Your Honor. I don't know how far he is in on the revocation that he has on the other charge, but he is a current state inmate. I know he's earned his GED. I know this would be his 5th felony, and like I said, I don't know how far he is in on that and when he would be eligible for parole. I do know, let's see, Your Honor, I just know he's a state inmate, that he got no credit on this, and I do believe from looking at the PSI, unless he can tell me different, that he probably still has some other charges pending, and so I can't say anything. I think, and I also think that he on the criminogenic need assessment. I will say this much on the needs assessment. It said that he rated very high. I very seldom see that, but basically, it was because he has no family support. It's the highest I've seen as far as family support, family and social support rated all the way out on the chart. Very high. I got a 5 out of 5 on that. So, and then his peer associates and criminal behavior ranked right behind that. So that made this very high, but evidently he's had a very hard childhood upbringing and has had no support, and consequently has led to some bad choices, and this would be a 5th felony, and I don't know what he may still have pending, Your Honor. But at this point, he is a current state inmate.
Thank you, Ms. Lee. Mr. Riley, would you like to make a statement?
No, sir.
Mr. Riley, the court finds you guilty of fraudulent use of a credit card over $500 under $10,000 for a 6-month period. I will sentence you to 2 months or 2 years rather on that charge. Receipt of a credit card in violation of KRS 434.570. Find you guilty of that, sentence you to 12 months. I'll run your sentences concurrent. They'll be consecutive to any other sentence that you might have. And its total sentence is 2 years. Court has considered probation or conditional discharge. It is of the opinion that imprisonment is necessary because there is a substantial risk that during a period of probation or conditional discharge, the defendant will commit another crime. The defendant is in need of correctional treatment, provided most effectively by his commitment to a correctional institution, and a disposition of probation would unduly depreciate the seriousness of the defendant's crime. In addition to the jail sentence, court does order restitution in the amount of, $4,281.78. That's to Lowe's. It's payable to the Bracken Circuit Clerk at a rate of no less than $200 a month. That's after you get out of prison. All right, Mr. Riley, what are Mr. Riley's court costs and public advocate fee?
$525.
$525. Do you have any money to pay that, Mr. Riley?
No, sir.
I will waive your court costs and your public advocate fee. Good luck, Mr. Riley. Right, who's next?
George West.
Commonwealth versus George A. West, 20 CR 834. Ms. Lee, do you represent Mr. West?
Yes, Your Honor, I do represent Mr. West.
Have you and Mr. West reviewed the PSI?
I have looked at it, and I took a copy to the jail for him to review, Your Honor. I don't see anything substantially wrong. If he has something, he can speak up and say now.
Okay, Mr. West, did you see anything wrong with the PSI?
No, sir.
Okay, Ms. Lee, do you wish to make a statement on Mr. West's behalf?
Yes, Your Honor. Unfortunately for Mr. West, he's had 3 prior convictions, Your Honor. This would be his 4th. Again, he is currently a state inmate. He has 43 days in on this 18-month sentence. Again, I don't know how far in, when he would be eligible for parole on the other charge that he's been revoked on. He does rate as high to reoffend. I will say, Your Honor, and I feel for people when I see these backgrounds that he only has a 6th grade education, and I know that that sometimes lack of education, lack of job opportunity leads to people making bad choices. Plus the fact that he had such a terrible childhood. When I read the facts surrounding his childhood, nevertheless, Your Honor, he has been revoked and is a current state inmate. So I can't ask you to probate this, knowing that I could, but he's not going anywhere at the present time. And I hope that when he comes out of this, that he will do better.
Mr. West, do you wish to make a statement?
Am I getting credit from since November when I got arrested for these charges?
I'm sorry, Mr. West, I didn't understand what you said.
Am I getting credit since I've been arrested on these charges?
Well, you're probably not going to get double credit. So if you're serving state time now, you're probably not going to get credit for that, and you get credit for one or the other.
He got 43 days on this. The rest of the time is going to whatever that, the other charge that he's been revoked on.
So you'll get credit for it, Mr. West, but it may not go to this case.
Thank you.
Do you wish to make a statement, Mr. West?
Yes, sir.
Was it 19 CR 1041 that I revoked him on, Ms. Lee?
Let me just look.
In
back
March?
here.
No, that would have been in 2020.
Judge, you revoked him in 19-1043 in December.
1043.
Yeah.
There it is. Yep. Okay.
1043.
But that was just a misdemeanor.
It looks like 40.
I was arrested November 4th.
He was revoked in 19 CR 1041 also the same day.
I was arrested November 4th on these charges.
Yep. Okay.
And that was a felony.
Yeah, 1041 is a felony. Yeah, it's not, and he was sentenced for 18 months on that case. And there was a probation violation enhancement on that.
Okay. Mr. West, the court finds you guilty of disregarding a stop sign. I'll fine you $25 on that. First degree possession of controlled substance opiates, I'll sentence you to 18 months. Possession of drug paraphernalia, 12 months. Possession of marijuana, 45 days. First degree possession of a controlled substance, methamphetamine, first offense, 18 months. Those all run concurrent, at least the jail sentence as well, for a total of 18 months. Of course, they'll run consecutive to any sentence you're serving now. Court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because there is a substantial risk that during a period of probation or conditional discharge, the defendant will commit another crime. The defendant is in need of correctional treatment that can be provided most effectively by his commitment to a correctional institution, and the disposition of probation would unduly depreciate the seriousness of the defendant's crime. Court costs and public advocate fee and fines are
$550.
$550. Do you have any money to pay that, Mr. West?
No, sir.
I will waive those costs and fines. And Ms. Lee, at some point, I believe Mr. West will be paroled on the one he's serving now.
Yep.
I presume you're going to be making a motion for shock probation. Make sure you put in your shock probation motion that he's been paroled,
Okay.
if he has been.
Okay.
Okay, thank you. Good luck to you, Mr. West.
Thank you.
the parole, they're running a little bit behind on some of those. And I know they're coming up, but they're running a little behind on notifying people. So
Okay, Ms. Lee, thank you. All right, who's that? What's your name, sir?
Kenneth Bledsoe.
Thank you. Commonwealth versus Kenneth Dustin Bledsoe, 20 CR 42. Ms. Lee, you represent Mr. Bledsoe.
yes, I do, Your Honor.
Have you and Mr. Bledsoe reviewed the PSI?
I've looked at it. I took a copy to jail for him to look at, and I see one error if he doesn't see anything. I see that on page 11, it says that he has no prior felonies, but he has at least one because he was revoked and he's serving out time as a state inmate now. So that's an error, Your Honor.
Okay, I'll correct that. Thank you. Anything else that you've noticed?
That's all that I noticed. I just have something to say on his behalf.
Yes, sir. Or yes, ma'am. I'll hear it.
Okay, so Mr. Bledsoe is a current state inmate, and I want to say that he has been working on trying to get some help with his addiction. Your Honor, he has, this is an 18-month sentence, and he only has 1 day credit on this because he is a state inmate. But we are just on the edge, Your Honor, of the 6 months that we had to file for shock probation on him. So we have filed for shock probation. It's in Judge Kaltenbach's court. And so I don't know what Judge Kaltenbach's going to do, but I hope that he grants it because he was revoked on November 23rd. So we are on the very edge. And Mr. Bledsoe has a bed date on May the 17th at Teen Challenge. I believe Miss Garrison is on the line here. We know we've made arrangements for that. If the court will see to give him probation on this, and hopefully he will get the probation on the other one before we run out of time, then he'll be able to go to Teen Challenge. I think Miss Garrison said we can even get some transportation for him so that we can help him on his way toward that. He is a moderate risk. He is a high school graduate, Your Honor, so we know that he can read and write, and he would probably do well up there in the Teen Challenge program. So we're hoping that the court will see fit to go ahead and probate him, and hopefully he will be able to get shocked by Judge Kaltenbach on the other charge so that he'll be able to make the bed date into Teen Challenge.
Thank you, Ms. Lee. Mr. Bledsoe, do you wish to make a statement?
No, Your Honor.
Miss Garrison online, Miss Emily Garrison, are you here? I hope I said that right. I don't see her. I thought she was online, but we did have the letter for Teen Challenge.
Audrey, I'm gonna look for the letter at this time. What's his first name?
It's Kenneth Bledsoe. Yana, did you get a copy of the letter? I thought Miss Garrison
No,
was sending.
I didn't, Ms. Lee.
Okay. Belinda's gonna get it. Belinda, I have a copy right here. Belinda's gonna send it. I thought Miss Garrison said she was sending it over again this morning in case that you didn't get a copy of it. Okay. So but we do have one, and we'll
I'm
send it.
looking at a copy of it now.
Okay.
Mr. Bledsoe, the court finds you guilty of first-degree possession of a controlled substance, methamphetamine, second or greater offense, and sentences you to 18 months. Possession of drug paraphernalia, 12 months. What concerns the court, Mr. Bledsoe, and I'm actually speaking because I still haven't made up my mind what I'm going to do. The concern of the court is you committed this offense while you were on probation for trafficking in methamphetamine. And you got a 5-year sentence in that case. I don't know what Judge Kaltenbach is going to do. Frankly, I just don't know what he's going to do with that. And of course, what I do here is not going to influence Judge Kaltenbach at all. He's either going to grant shock probation or he's not going to grant shock probation. And I don't know, frankly, once I don't know about Judge Kaltenbach, but once I revoke somebody, it's hard to get me to shock him again. It's not, I'm going to say it, I won't say it hadn't happened, but anyway, Mr. Bledsoe, I'm going to probate your sentence for a period of 3 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by our probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer, that you pay your $30 a month supervision fee, undergo a drug and or alcohol assessment, follow through with any recommended treatment and or aftercare, enroll in and successfully complete moral recognition therapy. You will be randomly drug screened. You'll have to pay for that, and you are subject to graduated sanctions by probation and parole. Now, whether you get to do any of that, that's not going to be up to me. I think you should. In fact, I'm going to complete Teen Challenge. I know you've got that bed date. You're probably not going to make that bed date, but you might. Who knows? But if you don't make that bed date, get another one for Teen Challenge and complete that program as part of your probation if you're granted that opportunity. Court costs and public advocate fee are
$525.
$525. Do you have money to pay that, Mr. Bledsoe?
No, Your Honor.
I will waive the court costs and the public advocate fee. Mr. Bledsoe, regardless of what happens, you've got a serious addiction, I think. And I see so many people just like you every day. And what I do know is that it's going to take a lot of work on your part to break that cycle. You can do it. I've seen people do it, but you just have to be prepared to go. And it's going to be painful for you, but you have to be prepared to go through that pain and get the work done so that you can get the active addiction behind you. So I wish you the best. I hope you'll take advantage of that, because you certainly don't want to come back here more of the same. So I wish you the best, Mr. Bledsoe. Good luck.
Thank you.
Who's next?
Christopher Fontana.
Good afternoon, Judge Peyton Wilson on behalf of Mr. Fontana.
Thank you, Mr. Fontana. He has, looks like 4 cases.
I think there's
252 or several cases.
that's right,
20 CR
Judge.
252, 20 CR 254, 20 CR 392, 20 CR 394, 20 CR 666, 20 CR 572.
That's right.
All right. So Mr. Fontana waived his PSI, and I think I wouldn't sentence him before because I didn't have the waiver in my hand.
I believe so.
But I have the waiver now. Mr. Fontana, you understand that by waiving your PSI, I'm going to sentence you to prison. Do you understand that?
Yes, sir.
Okay. Do you wish to make any statements, Mr. Fontana?
No, sir.
Mr. Wilson, do you wish to make any statements?
No, sir.
All right. In case 20 CR 252, court finds you guilty of theft by unlawful taking over $500 under $10,000 and sentences you to 18 months. That's consecutive to any other case that you might have. And Court orders restitution in the amount of $1,000 to AT&T on US Highway 60 in Paducah. And that will be payable through the McCracken Circuit Clerk. That'll be due at a rate of $200 a month. Well, I'll get to the amount of monthly payment after that, after we finish. In case 20 CR 254. Court finds you guilty of theft by unlawful taking over $500 under $10,000 and sentences you to 18 months consecutive with any other case that you might have. Additionally, the court orders restitution in the amount of $1,100 to Best Buy in Paducah, payable through the McCracken Circuit Clerk. Case 20 CR 392. Court finds you guilty of first-degree criminal possession of a forged instrument, sentences you to 5 years. That is consecutive to any other case that you might have. In case 20 CR 394, court finds you guilty of theft by unlawful taking over $500 under $10,000 and sentences you to 5 years. First-degree criminal mischief, 5 years, and second-degree burglary, that sentence is also 5 years. These will all run concurrent in this case for 5 years, but consecutive to any other case that you might have. In addition, the court orders restitution in the amount of $50 to Barry McNeil. That's payable through the McCracken Circuit Clerk. And in case 20 CR 666. Let's see, 572. There it is. Court finds you guilty of theft by unlawful taking over $500 under $10,000, sentences you to 18 months. Additionally, the court orders you to pay restitution in the amount of $1,049 to Walmart. That is on Irvin Cobb Drive. That's payable through the McCracken Circuit Clerk. And in case 20 CR 572, the court finds you guilty of theft by unlawful taking over $500 under $10,000 and sentences you to 18 months. Again, that's all of these separate cases are consecutive. Court also orders restitution in the amount of $1,100 that's payable to the AT&T store in Paducah through the McCracken Circuit Clerk. Court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because there is a substantial probability that during a period of probation or conditional discharge, the defendant will commit another crime. The defendant is in need of correctional treatment that can be provided most effectively by his commitment to a correctional institution and the disposition of probation would duly depreciate the seriousness of the defendant's crime. Restitution is ordered to be paid at a rate of no less than $300 per month once he's released from prison.
Hey, bro, you finna have to lower that. What you want me to do? Get out and sell some dope?
Mr. Fontana, if I may, that restitution obligation won't take shape until you're released. And as far as vocational assistance, I mean, the parole board and any parole opportunities, they're going to try to set you up. And I would be well inclined to tell you, hey, look forward to any of those vocational assistance programs that they offer at that time.
Yeah.
Court costs and public advocate fees are in these cases.
For all of them, it's $3,150.
Do you have any money to pay that, Mr. Fontana?
No.
Okay. Court will waive your court costs and your public advocate fees. Good luck, Mr. Fontana.
Thank you, Judge. Judge, that's all that I had before you this afternoon, if I might be excused.
Yes, sir.
Thank you.
What is your name, sir?
Rocky Reese.
Thank you, Mr. Reese. Commonwealth versus Rocky R. Reese Jr., 20 CR 820. Do we have Mr. Knoll on the line?
I think I'm here, Judge.
I see the top of your head, Mr. Knoll. Let's see if we can.
Well, let's see, I can stand up a little bit. I don't know what I need to do there.
Can you just tilt it down a little bit? That might help.
Okay, maybe that'll do it. Okay, there I am.
That's perfect. Thank you. Mr. Knoll,
Thank you.
Reese reviewed the PSI.
Yes, Your Honor, and I sent a copy of it to Mr. Reese in jail, and it was basically a continuation or an update from the prior one that he had in Marshall County.
Okay. Are there any corrections that need to be made, Mr. Knoll?
Judge, this would probably be minor, but in the on page 9, his mother's surname has been changed. She is remarried, and her name is Stephanie Nemo, Nimno. And the two brothers that are listed on that page have a different address than her mother's, and they're living at the mother's house now, which is 107 Highland Drive.
Thank you. Any other corrections, Mr. Knoll?
No, no.
Thank you. Do you wish to make a statement on Mr. Reese's behalf?
Yes, Judge. You know, I know the court's aware of this, but he received a 2-year sentence in Marshall County on March 24th of 2020. It was a supervised probation, and these offenses occurred on 10/31 of 20. Based on that, he would of course like to be probated, but if his problem so far is just marijuana, even going back according to the PSI at age 12. And so he is trying to get enrolled in the SAP program, and I think he will be able to do that. And would like to at least be, if not probated by the court, at least be considered for shock probation in the future, which of course is not before you at this point.
Thank you, Mr. Knoll. Mr. Reese, do you wish to make a statement?
No, sir.
Mr. Reese, the court finds you guilty of first-degree fleeing or evading police on foot and sentences you to 5 years. 2 counts of tampering the physical evidence, sentence you to 5 years on each of those counts. Possession of a handgun by a convicted felon, 5 years. Trafficking in marijuana with a firearm enhancement, 5 years. Those will all run concurrent for a total of 5 years. This sentence will run consecutive to any other sentence you might have in any other case. Court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because there is a substantial risk that during a period of probation or conditional discharge, the defendant would commit another crime. The defendant is in need of correctional treatment that can be provided most effectively by his commitment to a correctional institution, and a disposition of probation would unduly depreciate the seriousness of the defendant's crime. Court costs are
$175.
$175. Do you have money to pay that, Mr. Reese?
No, sir.
I will waive your court costs. Good luck to you, Mr. Reese.
Thank you.
And,
Thank you, Your Honor. May I be excused?
There is one quick matter. The Commonwealth has tendered a forfeiture order. Have you seen that by any chance, Mr. Knoll?
I don't know. I have not seen it, but I mean, I anticipated it. There was some money, $300, I believe. In fact, actually,
$595 looks like, yeah. And I think wasn't it a condition of his accepting the plea agreement that he forfeit all items seized?
Yes, sir. Yes, sir.
So I'll go ahead and sign this order of forfeiture then.
Thank you. May I be excused now?
May.
Thank
Yes,
you.
Sir. All right, who's left there in the jail courtroom?
Robert Maxey, Your Honor.
Thank you.
I represent Mr. Maxey, Your Honor.
Thank you, Mr. Walter. Have you and Mr. Maxey reviewed the PSI?
We have, Your Honor.
Are there any corrections that need to be made?
On the looks like the third page, his address at that time was 4131 Clarks River Road. That needs to be changed to 2318 Highway 1394.
Did I say something?
Just a minute, please, Mr. Maxey. Let your attorney finish. I'll get to you in a minute.
Yes, sir.
East Bernstadt, Kentucky, 40729.
Okay, thank you. Any other corrections that need to be made, Mr. Walter?
He's been shown a jail credit of 227 days. It's my understanding that that may be a little short. That was as of last year, June 29th of 2020. He's done some substantial time since then, so I think it's more than 227 days. I brought that to the attention of Ms. Atherton, and she indicated that she will do an audit on that.
Because I'm showing 199 days.
The documentation that I have attached to the PSI shows 227 days.
I may be looking at something that's out of date. Did we have to continue, Mr. Maxey's, because maybe
We did.
COVID? And I don't know.
Well,
that
a couple of other matters, yes.
Yeah, and I don't know that I've got the updated number, but, oh, wait. No, is this his? No, that's a co-defendant.
And I know Mr. Maxey has seen his PSI. He sounds like he may have some corrections I was not aware of.
Okay, and just a minute. So you're, how many days are you saying, Mr. Walter?
Pardon me?
How many days credit are you seeing?
I'm showing on the PSI that I have 227.
Okay.
That was as of June 29th, 2020. He's done some time since the fall of 2020. So I think, I would think he was 283 days, but I don't have a specific amount. And Ms. Atherton indicated that she would audit that.
Okay. All right. Now, Mr. Maxey, did you have corrections that you believe needed to be made?
Yes, Your Honor. The address that you were saying that was my grandmother's, my wife's grandmother's address, but our current address is 75 Tevis, Mount Vernon, Kentucky, I think it's 40456.
Oh, that's what I have in the PSI. Okay.
Yes.
My apologies.
That's my permanent address.
Okay.
My wife's grandmother is, at this point, she moved from that house due to her husband had passed away in the living room. So she moved over there close to her daughter's house at this time right now.
Mr. Walter, do you wish to make a statement on Mr. Maxey's behalf?
Yes, Your Honor. By this time, Mr. Maxey should be quite familiar to the court. He's pled guilty to 2 misdemeanors that he's to be sentenced on here. The difficulty, as you well know, and as Mr. Maxey recognizes, is that he's been in the wind for 7 years. However, during that time, he has served substantial time in jail on 2 misdemeanors that amount to 2 years. You know his physical difficulties. He's having to sit right now because of his orthopedic problems with his legs, his heart condition, his lung condition, the various problems that he has, which are substantial and are well documented in the file. He has family concerns that are grave, if not dire, involving his 6-year-old daughter and a drug overdose, which she sustained within the last 2 to 3 weeks. She's now out of the hospital in Corbin and requires therapy. His wife has a high-risk pregnancy. She is being detained at a motel in Eastern Kentucky, I believe in the Corbin or Somerset area. He's done quite a bit of time that I think goes a long way towards justifying a conditional discharge on this particular case. He was supposed to be sentenced last fall, but he was undergoing treatment for various maladies. He's had surgery. He's had orthopedic surgery. This gentleman has a lot of problems. Jail's not a good place for him to be as far as the medical treatment that he needs. Family problems, I think, justify allowing a suspended sentence on the rest of his time. I appreciate that he has not been cooperative in the past, but he's here now. He's done substantial time and he's paying a price for it. We would ask that he be suspended on the remainder of his misdemeanor sentence.
Thank you, Mr. Walter. Mr. Maxey, would you like to make a statement, sir?
Everything that Mr. Walter said is true, Your Honor. And I'm having issues to climbing. They got me climbing on a top bunk and almost fell off of it. And they said that my legs is not going to be getting any better. I'm going to end up in a wheelchair for the rest of my life. Much as I don't like that, I love to walk, and I was hoping that I can walk and everything until the day the good Lord takes my legs away. But I don't have no choice over that. But I'm suffering with the conditions that I have. It's something I have to live with.
Mr. Maxey, the court finds you guilty of theft by unlawful taking under $500 and sentences you to 12 months. The court also finds you guilty of criminal attempt to tampering of physical evidence and sentences you to 12 months. Those will run concurrent for a total of 12 months. You have a contempt of court for your failing to appear for sentencing on January the 8th, 2014. That is dismissed. If you have any other contempts, those are dismissed as well. Mr. Maxey, I would be extremely sympathetic to your case had you not failed to appear for sentencing twice. I can't forgive that. Court has considered conditional discharge or probation, but is of the opinion that imprisonment is necessary because a disposition of probation or conditional discharge would unduly depreciate the seriousness of the defendant's actions. Mr. Walter, now, the only thing I can do now is give him the 227 days credit. I am amenable to altering the judgment to give him greater credit if it is warranted, but I need DOC to compute that and let me know how many days he's actually entitled to.
Yes, sir.
So as soon as I get that, I will amend my final judgment to reflect additional days credit if it's warranted, but as of now, he's entitled to 227 days toward the period of 12 months. Good luck to you, Mr. Maxey.
Thank you, Your Honor. May I be excused?
Yes, sir, Mr. Walter.
Thank you.
What? 227 days credit. Did we have Ms. McDonald on today?
Yes.
She wasn't in there.
I'm here, Your Honor.
Where are you, Ms. McDonald?
I am at home, and that is per my attorney's office. They should have submitted a note for you where that might
did.
also
We did.
not let me travel.
Your Honor, we sent a medical note, but I advised her that she needed to be on Zoom if she couldn't get here in person.
Okay, I see what this. When are you going to be able to appear in person, Ms. McDonald?
Pardon me, Your Honor.
When will you be able to appear in person?
As the letter states, not until my baby is born. And
Yep.
my due date is November the 2nd, Your Honor.
Yes, I knew from her pregnancy is just that in like the first trimester, so it would be quite some time before she'd be able to come. And they said she could not travel right now. So she gives a November 2nd due date, Your Honor, right now. So sometime out from there, maybe. The doctor's office says she high risk, so she can't travel right now.
Sentencing December the 6th.
December the 6th,
9
Your
a.m.
Honor.
Yes, December the 6th at 9 a.m.
Okay, I'll put it on my calendar.
Thank you,
And,
Your Honor.
Ma'am, and we'll see you at the McCracken County Jail then when you come for your sentencing.
Yes, sir. Am I going to remain on the ankle monitor, sir?
Yes, ma'am.
Thank you, sir.
You're welcome. All right, who's there in the jail right now? What's your name, ma'am?
Vicki Presley.
Thank you. Commonwealth versus Vicki Lynn Presley, 19 CR 1084, 19 CR 1100.
Your Honor, I represent Ms. Presley.
Thank you, Mr. Brown. Have you and Ms. Presley reviewed the PSI?
We have, Your Honor. We just have a few corrections. The jail credit reflects there's 0 days on the 19 CR 1100-2 case, but I believe she has 2 separate cases. I think there's 9 days credit on each. She is given a total credit of 18 days on the one case, which I think is accurate for the total for both. But we saw that. I think that it was an instance where she had bonded out separately in each of those cases. So, Your Honor, I'm reviewing this. The other error that we saw is there's a few out-of-state, looks like misdemeanor cases that the disposition's unknown. I spoke to Ms. Presley. She believes she's since resolved these. These are very old, from around 2007, 2009. So I believe those have been resolved. So this is the only case that she has pending to deal with, Your Honor.
Okay.
Other than that, I don't think we found any other major errors or omissions, Your Honor. I just wish to be heard on probation today, Your Honor.
Yes, sir, Mr. Brown. I'll hear you.
Your Honor, Ms. Presley does come back as a moderate risk. Looking through the PSI report, she has an extremely limited criminal history. This would be the first felony convictions that she is dealing with. These cases have been pending for a while. She's managed to abide by the conditions of her bond, stay out of trouble. I think coupled with the fact that she has a limited record, these are possession cases, Your Honor. I think that she'd be a great candidate for probation. I think she's demonstrated she can follow the court's orders, do what she's supposed to do while this case has been pending. So we would just respectfully ask the court to consider probation, Your Honor.
Thank you, Mr. Brown. Ms. Presley, would you like to make a statement?
No. I just hope I make it on probation.
I beg your pardon, ma'am?
Just want to get my life turned around and make it for probation.
I have a lot of things going on in my life. My mom just passed away and I can't find my child, so I'm working on those.
Ms. Presley, in case 19 CR 1084, the court finds you guilty of expired registration plates, fines you $25, failure to register the transfer of a motor vehicle, fine you $25, failure of owner to maintain required insurance, first offense, sentence you to 90 days. First degree possession of a controlled substance, methamphetamine, I will sentence you to 1 year. Possession of drug paraphernalia, 12 months, and failure to notify DOT of your address change, 90 days. Those will all be concurrent for a total of 1 year. Then in case, or leave the jail sentences, then you've got the fines on top of that. Then in case 19 CR 1100, the court finds you guilty of first degree possession of a controlled substance, methamphetamine, first offense, and sentences you to 18 months. Possession of drug paraphernalia, 12 months. Those will be concurrent for a total of 18 months. These sentences in each of these cases will be consecutive for a total sentence of 2.5 years. Court will probate your sentence for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that you report as directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer, pay your $30 a month supervision fee, undergo a drug and/or alcohol assessment, follow through with any recommended treatment and/or aftercare, enroll in and successfully complete moral recognition therapy, random drug screens at your cost, and you are subject to graduated sanctions by probation and parole. Court costs and public advocate fees are?
The total, Judge, is going to be 1,000 and, I'm sorry, wait. It's gonna be $1,100 even.
Okay. Ms. Presley, if I give you time to pay your court costs, can you do that?
Actually, I'm having a little trouble, like, getting a driver's license right now, but I'm working on that. But I don't have a job at the moment.
Okay,
But
well,
if you could give me time, I could make some kind of payments on it.
well, I think you should be able to pay $100 a month, don't you?
I hope so. I know that he said that they had released, because my birth certificate and all that stuff was in my truck when they took it. So he said that they released that, so I'm gonna go there and see if they still have that there.
Okay, I'm going to give you until May the 13th at 10:30 to have your court costs paid. If they are paid by then, I won't need to see you back in court. If they're not paid by then, I'm going to need to see you May the 13th. And that's not tomorrow, that's 2022.
Okay,
All right?
thank you so much.
All right, Ms. Presley, you're going to have to give us your best effort on probation. So, because it looks to me like you got a meth problem.
Yeah, I understand.
If you're not prepared to give it your best effort, you might as well just say, put me in jail, Judge, because that's what's going to happen.
Yeah, I know.
Best effort?
Yes,
Okay.
I promise.
Good luck, Ms. Presley.
Thank you so much.
Commonwealth versus Hilton D. Murphy, 19 CR 1100.
Judge, represent Mr. Murphy. This is his sentencing.
Okay, Mr. Schultz, have you and Mr. Murphy reviewed the PSI?
Yes, Judge. On page 5, it indicates that he's got a 2020 criminal abuse 3rd degree. That should say criminal trespass 3rd degree. If you look 20M1468 up, that's what it is.
Yeah, that's a big difference, isn't it?
Yes, Judge.
Very well, that correction's made. Anything else, Mr. Schultz?
We did not see anything else that was incorrect on the PSI, Judge.
Okay, do you wish to make a statement on Mr. Murphy's behalf?
Yes, Judge. I just point out that he doesn't have a previous felony. He'd be presumptively probatable. He has a place to live. He's willing to comply with the terms of that probation, and we would respectfully request probation, Judge.
Okay, thank you, Mr. Schultz. Mr. Murphy, do you wish to make a statement?
Motion.
Mr. Murphy, the court finds you guilty of first-degree possession of a controlled substance, methamphetamine, first offense, and sentences you to 18 months. Possession of drug paraphernalia, 12 months, and third-degree possession of a controlled substance, 12 months. Those sentences will run concurrent for a total of 18 months. Your sentence will be probated for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer. Pay your $30 a month supervision fee. Undergo a drug and/or alcohol assessment. Follow through with any recommended treatment and/or aftercare. Enroll in and successfully complete moral recognition therapy. You will be randomly drug screened. You'll have to pay for that, and you are subject to all graduated sanctions by probation and parole. Court costs and public advocate, or court costs rather, are
$195.
$195, and you're at private counsel, Mr. Schultz?
Yes, Judge.
$195. When will you be able to pay that, Mr. Murphy?
Could I have a couple of months?
Yes, sir. I'm going to give you 6 months. November the 12th at 10:30 a.m. If you'll pay them by then, I won't need to see you back in court. If it's not paid by then, I'm going to need to see you November the 12th at 10:30 a.m.
Thank you, Judge.
Good luck, Mr. Murphy.
Sir, may I ask you a question?
Yes, sir.
The bond I put up, how does that work? Did I get that back?
Yourself, or did somebody post it for you?
Myself.
Typically, if you post it yourself, I would expect you to pay your court costs out of that bond, and then I'd give the rest of it back to you. So you can talk to the clerk about doing that.
Okay, and that's across the street.
Yes, sir, at the circuit clerk's office.
But it'll be a couple days till the orders.
But we won't have, you can't do it right away. It's going to be a couple of days before the sentencing order is completed and over to them.
Yes, sir.
Okay. All right. Good luck to you, Mr. Murphy. Well, I do need you to go to probation and parole so that they can get so you can get on their supervision roll. All right. We do that.
Do I just go over there? Do I need to call my appointment?
No, you just go right over there.
Thank you very much, sir.
Okay. Good luck.
Thank you, Judge. It's all my business. Can I be excused?
Yes, sir. All right, who's in the jail now?
Jared, who's in?
Wait, just a minute. Who's seated there in the courtroom?
Me,
Yeah, what's your name, ma'am?
Destiny Baker.
Mr. Hinsman,
Yes, sir.
I'm going to do Miss Baker first. She was there before you came in. Ms. Lee, you represent Miss Baker?
Yes, I do, Your Honor.
Are there any, have you reviewed the PSI with her?
I have, and I sent this to her by email, so that she can review it.
Okay, any corrections that need to be made?
I didn't see any, so she says she doesn't see any either.
Do you wish to make a statement on her behalf?
Yes, Your Honor. This was like 2 cases, and I think they're just like right together. The big thing here on this one is the restitution, which she is willing to pay. She is working now. I think she's working at Wendy's. So she is working. She's a sole support for her kids. She's a single mom of 2 young kids. Your Honor, I looked at her criminogenic needs, and it says the assessment says she rates low. She is a high school graduate, so she can get out and work. she, like I said, she wants to pay this. I was looking to see if she had anything while she was out. And I wanted to say that she hadn't gotten any new offenses, but I think it looks like she has a charge there. But I checked the dates and it looked like this all happened back in September, about the same time that all this was happening. So this is one of those cases where you have a charge, a late charge that's just catching up. It should have been done at the same time as others. So it's not like she did something while she was out, Your Honor. So she, like I said, she's got 2 young kids at home and she's working and she's their sole provider. So we would ask that the court would probate her and let her do MRT, let her continue to work and pay back this considerable amount of restitution that needs to be paid. That's what that's all I had to say. We'll ask to the court for that.
Thank you, Ms. Lee. Ms. Baker, would you like to make a statement?
I do have a question. What is MRT?
It is moral recognition therapy, designed to help you the consequences of your actions and not so much as make impulse decisions.
Mm-hmm. And yeah, I think this was well, I can't say it was impulse, but these 2 felonies here are like first and second. So she hadn't had anything before then. So I don't know what was going through her brain. I know what she says was going through her brain, but she was kind of desperate at the time. So
okay. All right, Ms. Baker, do you wish to say anything else?
That if you give me probation, I will pay restitution and I will not be in trouble no more at all.
Okay. Ms. Baker, in case 20 CR 780, the court finds you guilty of theft by unlawful taking over $500 under $10,000 and sentences you to 2 years. Additionally, the court orders restitution in the amount of $3,081.05. I believe that is to Walmart on Irvin Cobb Drive. That'll be due at a rate of $150 a month. Then in case 20 CR 782, the court finds you guilty of theft by deception over $500 under $10,000, sentences you to 2 years on that case. Court orders restitution in the amount of $3,114.10. That is due to Walmart on South Side Walmart, Irvin Cobb Drive. That's also due at a rate of $150 a month. Your sentence will be probated for a period of 2 years. Actually, make 2 years or until probation is paid in full. I mean, until restitution is paid in full, whatever occurs first or later. I mean, I'm having a hard time speaking now. Whatever occurs later, you get the restitution paid or 2 years elapsed. Continue good behavior, refrain from violating the law in any respect. Report is directed by your probation officer. Comply with the regulations of the Division of Probation and Parole and the directions of your probation officer. Pay your $30 a month supervision fee. If determined necessary by probation and parole, undergo a drug and or alcohol assessment and follow through with any recommended treatment or aftercare. Enroll in and successfully complete moral recognition therapy. You will be randomly drug screened while you're on probation. You'll have to pay for that. You are subject to graduated sanctions by probation and parole. And again, a condition of your probation is that you pay your restitution as ordered. If you are unable to pay the $300 a month, you can petition the court to lower it, but I expect you to make a good faith effort to pay it as it's ordered. Ms. Baker, you have to understand, if you steal anything else while you're on probation, you will get the maximum sentence that I can see that you get, and you will serve 4 years on these 2 charges.
Yes,
So
sir.
if you're thinking about stealing something, or if you have thoughts of stealing something while you're in Walmart or anyplace else, think about doing 4 years in prison, because you will do it.
Yes, sir.
Court costs and public advocate fee are
$1,050.
$1,050. Are you able to pay that?
Not at the moment. I can put $100 on something today.
Okay. I'm going to waive your court costs and your public advocate fee. I'd like the restitution paid.
Thank you.
Remember what I said, Ms. Baker, and I think you've got another case coming through the system.
Okay.
Don't do anything from here on out, because if you do, it's going to cost you big time.
I completely understand.
Okay. Good luck, Ms. Baker.
Thank you.
Oh, I need you to go over to probation and parole from here so they get you on their caseload.
Where is that at?
Right across the street.
All right, thank you.
Mr. Hinsman. Commonwealth versus Garrett L. Hinsman, 20 CR 612, 20 CR 676.
Afternoon, Your Honor.
Is that Mr. Yates?
It is, Your Honor, for Mr. Hinsman.
Thank you. Have you and Mr. Hinsman reviewed the PSI?
We have, Your Honor. There's no additions or corrections to make. Just like to address probation, please.
Yes, sir. I'll hear your argument.
Your Honor, in discussing what has gone on with Mr. Hinsman on the phone yesterday, I was looking for a common theme, and I think you summed it up earlier with one of the defendants where you said the best effort is what's needed. Mr. Hinsman was before you in January, and you sanctioned him and let him get back out. And what he's done, even though given enough rope to hang himself, he's done very well. He's maintained employment. He is kept in contact with me, kept in contact with probation parole. He's continued to do the IOP at Fort Rivers, and actually was called in, I think, a couple of weeks ago for a drug screen that was negative. So he's really put forth his best effort and has all intentions of maintaining that in an effort to stay out, be able to continue employment, be able to be involved in the lives of his children. And with the progress that he's made so far, Your Honor, we just ask that the sentence be probated today.
Thank you, Mr. Yates. Mr. Hinsman, would you like to make a statement?
Pretty much what he said, man. I got 3 kids, and if you'll probate me today, I'll keep on the same path and just keep doing the right thing.
Mr. Hinsman, in case 20 CR 612, the court finds you guilty of disregarding, actually, that was dismissed, so I don't even know why that's here. Court finds you guilty of expired registration plate, fine you $25. Operating on a suspended license, I'll sentence you to 90 days. Possession of drug paraphernalia, I'll sentence you to 12 months. First degree possession of a controlled substance, methamphetamine, first offense, 18 months. Possession of marijuana, 45 days. Those will all run concurrent for a total of 18 months. Case 20 CR 676, court finds you guilty of first degree possession of a controlled substance, methamphetamine, sentence you to 18 months. Possession of drug paraphernalia, 12 months. Those will run concurrent for a total of 18 months. These 18 months sentences will run consecutive for a total sentence of 36 months. And again, they're consecutive to any other sentence that you might have. Your sentence will be probated for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer, pay your $30 a month supervision fee, undergo a drug and or alcohol assessment, follow through with any recommended treatment and or aftercare, enroll in and successfully complete moral recognition therapy. You will be randomly drug screened and you'll have to pay for that. You are subject to graduated sanctions by probation and parole. And what Mr. Yates reminded us that I said was this is going to take your best effort. If you're not prepared to give it, then just tell us now and I'll put you in jail and we'll be done with it.
I'm ready.
So I want to give you the chance. All right, Mr. Hinsman, good luck to you. Just a minute, Mr. Hinsman. Mr. Orkosar.
The total is $375.
$375. When can you pay that, Mr. Hinsman?
If you could give me a couple months, I should have paid.
I'm going to give you until November. November the 12th at 10:30. If you haven't paid before then, I won't need to see you back. Otherwise, I do need to see you back. November the 12th at 10:30. Good luck, Mr. Hinsman.
Judge, I'd like to remind him that he has a court cost due July the 23rd. It was continued from February because of COVID. So he is on the docket for July the 23rd from his other case for court costs.
And how much was it?
It's $225. It's due July 23rd.
Okay, thank you.
All right, Mr. Hinsman, I need you to go right over to probation and parole so they can get you on their caseload.
Okay, thank you.
Yes, sir.
Thank you, Your Honor. That concludes my business with the court.
Thank you, Mr. Yates. Good afternoon, sir. Would you tell me your name, please?
Richard Lee Ham.
Thank you, Mr. Ham. This is Commonwealth versus Richard Lee Ham, 20 CR 414, 20 CR 640.
Judge, Mr. Reed, for representing Mr. Ham.
Thank you, Mr. Reed. Mr. Reed, have you and Mr. Ham reviewed the PSI?
Yes, we have, Judge. We have two small corrections. The first one being that his biological father now lives in Paducah and not Naples, Florida. And the second one is his stepfather is deceased. And those are the only corrections in the addition.
Okay, very well. Thank you. Do you wish to make a statement on Mr. Ham's behalf?
I do, Judge. Mr. Ham is 37 years old. Normally, I don't get into the facts of the case, but obviously the facts as written in PSI that he intentionally set the fire is obviously just not true. It was an accident at 2 o'clock in the morning. It didn't include the fact that he used a fire extinguisher to put out the fire himself and also knocked on doors to get everybody out of the building. Had pretty much out by the time they got there. And on the second case, Judge, the trafficking of the 3 pills, it doesn't also cover the fact that Mr. Ham took some of these pills himself and also he had a adverse reaction, not as bad as his good friend's girlfriend. But anyway, beyond that, Judge, I would just like to point out that Mr. Ham checked into Centerpoint Rehab on about December the 14th. He's been in there since that time. I'd gotten 3 letters from Centerpoint, and I got 2 on Monday and I got 1 yesterday. And the first 2 I got were just glowing. They're very positive about the work that he's done. And I've just never gotten a letter from Centerpoint just that positive, to be honest. So he is almost done. He obviously acknowledges that he's had a drug problem. While his criminal history, obviously about 9 years ago, there was another felony, but in the 8 years since then, he hasn't had any problems at all. So it does show, Judge, that he can at least he's not a troublemaker. But like many people who have substance abuse problems, sometimes it comes back. But obviously by doing almost 6 months now at Centerpoint, and the fact is, Judge, I believe he wants to continue on at Centerpoint, and I want to go ahead and turn it over to him. I think he wants to make a statement and talk about what he plans to do as soon as the as far as Centerpoint goes. Ricky, you want to tell the judge?
Yes, Ben. Right now I'm at Centerpoint, and a couple of the options there are after graduation to phase 2 or phase 3 apartment. Part of phase 2, one of the things I'm looking at is to peer mentor, so that way I can help other addicts like myself that have been in troubling situations. For some reason, while being there, I've been inspired because it's just something to do that's different, because I never pictured myself being able to do something different with my life. And over the course of the past 6 months, I've just learned that there's something different I can do. And, I need to hand things over and pay my part in that, help the next guy out, because that's what the program's all about, is sharing it with the next person. It's the only way I'm going to be able to stay sober. That's all I have, Your Honor.
Thank you, Mr. Ham. Mr. Ham, in case 20 CR 414, the court finds you guilty of second-degree wanton endangerment, sentences you to 12 months. Third-degree criminal mischief, sentence you to 90 days. Those will run concurrent for a total of 12 months. Case 20 CR 640, the court finds you guilty of first-degree trafficking in a controlled substance Percocet first offense and sentences you to 3 years. That will be consecutive. Mr. Ham, I'm appreciative of the work you have done to better yourself. since these offenses were committed. Fact of the matter is, however, a girl who you trafficked this Percocet laced with fentanyl very nearly died. So there's going to have to be some accountability for that.
Yes, sir.
Court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because the disposition of probation would unduly depreciate the seriousness of the defendant's crime. Court costs are
For both cases, it's $350, Judge.
And I will run the sentence in 20 CR 414. I'll run that concurrently with 20 CR 640. $350. Mr. Ham, do you have money to pay that?
Not on me, sir.
I will waive those court costs. Just a minute.
Don't run the arrow, that's for me, but on this case.
What is that?
The indictment warrant was.
Oh, well, let's just say that it is served. And because he's been here, so he doesn't need to be served again because he just pled guilty and been sentenced to it. So I don't know what they need to do. If they recall the warrant and say it's been served, I don't know how they need to fix it, but. All right, Mr. Ham, good luck to you, sir.
Thank you.
Judge, that's all I have. May I be excused?
Yes, sir, Mr. Reed.
Hi, Your Honor.
Good afternoon, sir. Would you tell me your name, please?
Michael Anthony Farmer.
Thank you. And this is case 19 CR 548.
John Straub for Mr. Farmer. I'm turning my video on, Your Honor.
All right, Mr. Farmer, let me find, or I mean, Mr. Straub, let me find you here. Mr. Straub, have you and Mr. Farmer reviewed the PSI?
I have reviewed it. I think I gave him an opportunity to look at it. I think he's okay moving forward.
Very well. Are there any corrections that need to be made?
No, sir.
Do you wish to make a statement on his behalf?
Briefly, Your Honor, we are asking for probation today. He is a subcontractor and self-employed. He does general construction, really a little bit of everything. And he stays really, really busy. He is covered up right now. And that's really good because he has three kids who live with him. And his wife is a stay-at-home mom. So it's my understanding that he's the only income for their family. I think one of the best arguments he has today really is that he's been on bond for about 2 years, and I don't see that he's had any problems. And the thing with this is he's really demonstrated an ability to be supervised. He's complied with everything, and he hasn't had his bond revoked. So that's really a good test run to see how he'll do on probation. And he has taken some positive steps. He has set up some anger management appointments, and I sent you and the prosecution an email showing that he did have an anger management appointment coming up on the 27th of this month. So we are respectfully asking for probation, Your Honor.
Thank you, Mr. Straub. Mr. Farmer, would you like to make a statement?
Yes, sir. First, I would like to apologize to Mr. Goetzer and his family for any kind of pain and suffering that I've caused, because obviously that wasn't me. I was a little intoxicated that night. And I'd like to apologize to the courts for any trouble I've caused for y'all too, but mainly to Gary and his family for any lost wages. And also I'm willing to do whatever it takes to make it right to him and his family. Your Honor, that's it.
Mr. Jones, I don't see a victim's impact statement.
I'm looking, Judge.
Oh, wait a minute. Yes, wait a minute. There's an email. Let me see if that's it. No, it's not a victim's impact statement. Was Mr. Goetzer contacted about sentencing today?
Judge, I'm showing he was contacted, and we have not received any
He was contacted with a letter and also a phone call. We were unable to get in contact with him,
right.
but he was contacted.
Okay, thank you. All right, the court has also considered a letter sent from Claire Stanley in the form of an email. Mr. Farmer, the court finds you guilty of second-degree assault and sentences you to 6 years. Court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because a disposition of probation would unduly depreciate the seriousness of your crime. Court costs and public advocate fee are?
$525.
Do you have any money to pay that, Mr. Farmer?
How much was it, sir?
$525.
My wife has the money outside. I don't have it.
Okay, so she can pay your costs then?
Yes, sir.
Okay, so I'll expect that to be done by May the 28th at 10:30.
And Your Honor, also I have money to pay on some money to pay on restitution also.
And I thank you for bringing that up. In addition to the jail sentence, Mr. Farmer, the court does order restitution in the amount of $2,783.06. That's to Shane Gocher, payable through the McCracken Circuit Clerk. They charge a 5% fee on top of the principal balance of the restitution.
Yes, sir.
They do at a rate of, that's not actually due until you're released from prison, Mr. Farmer, but that'll be due at a rate of no less than $200 per month once you're released.
Yes, sir.
Okay. Good luck to you, Mr. Farmer.
All right, thank you.
Afternoon, sir. Would you tell me your name, please?
Ricky Joe Barble.
Thank you, Mr. Varvel. See, Mr. Johnson represents Mr. Varvel.
Yes. Judge, we believe the PSI is correct and up to date. I would like to draw your attention to, let's see, page 9 is set to be updated in the near future. Let me check one other thing, what it says about his Illinois case. Yeah, he was probated to 30 months, so that is correct. On his probation in Illinois, he's completed the substance abuse forms and everything, and they've probated him over there. And I think as a condition of probation, he's supposed to be evaluated for rehab. He's going through the process. I think he's gotten an assessment or is about to. He's completed the forms, and he's wanting to be able to do the same thing here as a condition of his probation, follow through on a substance abuse assessment and with any recommendations that they might make. He advises that between his Kentucky case and his Illinois case, he's done 51 days in Kentucky and 39 in Illinois. So he's done 90 days of incarceration since picking up these charges. He looked at his record. He had a misdemeanor and a felony in Kentucky and a misdemeanor and felony in Illinois, and they were spaced out a great deal apart. But we think he's capable of doing probation and would like to ask for that.
Thank you, Mr. Johnson. Mr. Varvel, do you wish to make a statement?
Yes, Your Honor. I just wanted to tell the court that I am sorry for what I've done, and I understand that it was wrong. And since I've been out, I've done everything I can to better myself, including I've had a steady job, and I've been steadily going to my probation over in Illinois. And if you see fit, it would be great for me to continue to do that.
He did mention to me that this is kind of embarrassing for him because it didn't need to have happened. And that the age of his 17-year-old daughter, 12-year-old son, and his parents and everybody, he's not wanting anything like this to ever occur again.
Mr. Varvel, the court finds you guilty of first-degree trafficking in a controlled substance greater than 2 grams of methamphetamine and sentences you to 5 years. Court finds you guilty of possession of drug paraphernalia and sentences you to 12 months. Operating a vehicle with an expired operator's license, 90 days, and possession of marijuana, 45 days. Court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary, Mr. Varvel, and that is because the disposition of probation would unduly depreciate the seriousness of your crimes. Trafficking is a whole lot different from possession. If it were possession, I would probate your case. But you traffic, you're enabling other people to ruin their lives as well.
I understand.
Very seriously, and there has to be a stiffer penalty than what you've paid so far. Court costs and public advocate fee are
$525.
$525. That's going to be due on May the 13th, 2022 at 10:30. Mr. Varvel, I will strongly consider shock probation for you, but as it stands right now, I think you have to be in prison.
And Judge, in line with that, I don't know if Mr. Varvel, and I apologize for not having a jacket on. Mr. Jones caught me in the hall. Mr. Jones represented him when he started this case. But Mr. Varvel, I don't know if you have a drug issue, but if you were going to apply for shock probation and you do have a drug issue, you might want to be assessed for drug court as well.
Okay. Thank you, sir.
All right.
Good luck.
Judge, if he were to do that, would he need to ask for that today, or would he need to wait until he files a motion?
Probably needs to wait for file a motion. And I'm not even consider at least for probably 3 months or so.
Right. Okay. All right. But you're aware of it now, Mr. Varvel, right?
Yes, sir.
All right.
Okay.
All right, thank you.
All right. Good luck. Who's there in the jail? Do we have Richard Nestler there?
Yes, sir. Who you had?
Oh, I'm sorry. Yes, sir.
Okay, thank you, Mr. Nestler. Mr. Johnson, you represent Mr. Nestler?
Yes, Your Honor.
Have you and Mr. Nestler?
Reviewed the PSI and it appears to be correct. I think we're ready to for sentencing.
Very well. Do you wish to make a statement on Mr. Nestler's behalf?
Well, he's only had 2 things on his legal record in his life. They're both the same charge, a DUI, when he was 40 back in 2004. And then back in 2020, when he was 56, he had another DUI that had criminal mischief, wanton endangerment connected to it. he is disabled, is on medications. There were medications that he had taken during the incident that he was under the influence of. But we would like to submit for your consideration that we don't think this is likely to reoccur. He has not been a reoccurring problem to the criminal justice system. It's something that's gotten his attention, and he is would like to be probated and would like to assure you that it's not going to happen again.
Mr. Dessler, would you like to make a statement?
Yes, I just wanted to apologize to the court for doing something so senseless. And to assure you it won't happen again, because I have not driven since that day. I don't even like to ride in cars, to be honest. I'm not driving ever again. That was it. I take more medicine now than I did then. So I've gotten cancer. I've had to take radiation for that. And so drinking's out completely now. And I just wanted to let you know that. Oh, and I'm on physical therapy. So I fall a lot. So I would like to keep up with that. So maybe I would follow it. Oh, say it's helping. Can I say one other thing?
Yes, sir.
Did you get this letter from Sarah Black?
I don't think it came through our office.
I gave it to the lady at the door, it's her office. It's my therapist, Sarah Black.
Just a second. If that's the case, I should have a copy scanned in my computer. I wasn't aware of it. It's going to take
She said it from Four Rivers.
like half a minute for me to be able to access it. Or less. Okay. I have a letter from therapist dated May 10th, and I think that might be, it's from your therapist, Sarah Black, at 425 Broadway, Four Rivers Behavioral Health. And to whom it may concern, you're a patient since 2019, diagnosed with anxiety and depression. You attend sessions regularly, you participate, incarceration would be detrimental to your mental health due to experiencing frequent panic attacks and declining health. It's Sarah Black, LPCA, Adult Services. So she did write that letter. We do have access. I don't think we tendered it to the judge, but I just explained it right now.
Okay, thank you, Mr. Johnson. Mr. Jones, I did not see a victim's impact statement. The victim in this case contacted?
They were, Judge, and we got nothing back.
Mr. Nestler, the court finds you guilty of DUI first offense, sentenced you to 30 days. Alcohol, drug education classes, $425 service fee. And your license will be suspended by an amount of time determined by Department of Transportation. First degree criminal mischief, court sentenced you to 3 years. First degree wanton endangerment, 2 counts, 3 years each. And there's a contempt of court for your failure to appear for your pretrial conference. I'll dismiss that. So, these sentences will all run concurrent for a total of 3 years. In addition, the court orders restitution in the amount of $5,400 to Demetric Burns and Shannon Matthews. That'll be payable through the McCracken Circuit Clerk's Office, and Edward Westrich in the amount of $200. That also is payable to the circuit clerk, or through the circuit clerk. That's due at a rate of no less than $200 per month. Having a hard time with this, Mr. Nestler.
Well, I assure you, I know exactly how bad it is. It's never gonna happen again. I mean, never gonna happen again. I said, I don't drive a car, I don't like to get in a car. Plus, honestly, I'm just not well enough to. I haven't found out about the radiation any good yet. I don't get a don't do blood test till July. To find out if I'm okay or not, I don't know. I mean, my family has passed away from it, so probably not. I don't know.
All right, Mr. Nestler, I'm going to probate your sentence for a period of 5 years.
Thank you.
Your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed to by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer. Pay a $30 a month supervision fee. If determined necessary by probation and parole, undergo a drug and/or alcohol assessment, follow through with any recommended treatment and/or aftercare. Continue your mental health treatment.
No.
Restitution payments in the amount I've already specified.
No.
You are subject to graduated sanctions by probation and parole. Also, I'm going to do not operate a motor vehicle while you're on probation.
That's not gonna be a problem, don't worry.
Do you think that's unreasonable?
No, I do not. It's not gonna be a problem. I'm not gonna drive. So no, it's not a problem at all. Don't worry. Not gonna be a problem.
If you change your mind, you can petition the court to reevaluate that. But as it stands right now, no driving. And if you do, then you'll be serving these 3 years.
Yeah. Since this happened, my medications went up and up and up. So it's definitely out of question now. It was hard to walk over it. Do I have to go? I'm sorry, you go ahead.
Court costs and public advocate fee are
$950.
$950. That is due on November the 12th. I think it's the 12th. Let me look. Think so?
Do I get a copy of all this stuff? Because I won't remember it.
You'll get a copy of my order, November the 12th at 10:30. That's when all this is due, all the court costs is due. If you haven't paid by then, you don't have to come back to court. If it's not paid by then, I'll see you November the 12th at 10:30 a.m. Don't forget your restitution payments. And if you will, please, Mr. Nestler, I need for you to go see probation and parole directly from here. They're across across, let's see, 6th Street.
The place over here where I took the paperwork.
So it's behind the jail.
Okay.
And your officer can help you keep up with your conditions as well.
Okay.
He can help you make sure you're doing what you need to be doing.
Okay. That'll work. Thank you very much.
Good luck, Mr. Nessler.
Thank you. I appreciate it.
Who do we have in the jail there?
Samantha Sachs.
Okay. Commonwealth versus Samantha Sachs. Mr. Johnson, you represent Ms. Sachs.
Yes, and this was an alternative plea deal, and I believe that her two co-defendants and her have made restitution, to my knowledge. Is that
right, Mr. Jones? Is Commonwealth satisfied the restitution's been paid?
Yes, Judge.
All right, Mr. Johnson, have you and Ms. Sachs reviewed the PSI?
I've reviewed the PSI and it appears to be correct, Your Honor.
Are there any change? Okay, so no changes need to be made then.
Well, just that restitution's been made.
Okay.
And she's asking to be probated.
Do you wish to make a statement on her behalf, Mr. Johnson?
Well, I think paying the restitution, I would hope, would have made the largest statement. And she is disabled, and one of her co-defendants is her husband, and she's asking for probation.
Okay, thank you very much. Ms. Sachs, do you wish to make a statement?
I apologize for everything that was done, and I assure you it will not happen again.
Ms. Sachs, you pled guilty to theft by deception over $500. A condition of your agreement was that if restitution was paid by sentencing, it would be reduced to theft by unlawful taking under $500, and you'd receive a 12-month sentence. So I find you guilty of theft by unlawful taking under $500, and sentence will be 12 months. Ms. Sachs, I appreciate that you paid restitution, and that gets you away from a felony conviction. But I've read what happened in this case, and frankly, I'm appalled. You took advantage of one of your employees. And that's, in my mind, that's just disgraceful. The court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because the disposition of probation would unduly depreciate the seriousness of the defendant's crime. So I'm going to put you in jail for 12 months, Ms. Sachs. I'm going to give you 1 day credit toward the service of that. Court costs and public advocate fee are
$525.
$525. Do you have money to pay that, Ms. Sachs?
Not at this moment.
Okay. I will waive your court costs, your public advocate fee. Good luck.
Thank you.
All right, who's next there?
Sir.
Do we have either Ronald Eugene Moore or Jason Eugene Sachs?
This is Jason Sachs. Yes, sir.
Okay.
Scott
Right,
Straub, Jason Sachs.
Thank you, Mr. Straub. Have you and Mr. Sachs reviewed the PSI?
I've reviewed it, Your Honor. It was here at the office available if you wanted to look over it, but I think we're ready.
Okay, very good. Do you wish to make a statement on his behalf?
Yes, sir. This is the same case with the agreement where if they paid restitution, he'd have a misdemeanor. He is very busy working, driving a truck, and let me see here. His mom is having some heart problems and also COPD, and he has children who live with him. And he's hoping to get back to work with the union, the 181 union, as soon as possible. His wife, who was there before he came up, has fibromyalgia, and she's in a lot of pain. And I saw he walked up there with a back brace on. He has a degenerative disc disease, and he's trying to deal with that. It sounds like he needs surgery from discussing it with him through email. So we are respectfully asking for probation.
Thank you, Mr. Straub. Mr. Sachs, do you wish to make a statement?
I do. Yes, sir.
I apologize wholeheartedly for the situation that came about. It was not set out. We never set out to take Mr. Zach's money or anything. It was an administrative error. And when I heard about it, I tried to fix it. The man that worked for me said that it would be fine, just come to court with him and explain. And so I was going to, but in between times he quit and I never did hear the court date. So we were trying to make attempts to pay this. I never set out to do anything. I would never set out to do anything to blindside or take money from someone. And I have messed up when I was younger. I have been in trouble when I was younger with drugs, and I moved here and completely changed everything. My life completely to raise kids and be a productive member of society. And with this business, I was overwhelmed, and I apologize that it went to the lengths that it did, but I had no intentions of ever taking advantage of anyone. It wasn't on purpose or anything like that. I just ask you that you don't split up my family over this. You know, my children is under my roof and I'm the only person that works in our household. So I'm just, I'm hoping that we can not destroy my family and everything that I've worked for 20 years. Well, 18. I was last in trouble in 04 and I got out in 05 and I moved here. And I have not looked back or been around them kind of people since. I mean, I've really put strides toward making a better life, and that my kids would never know that type of lifestyle, you know, the drugs and the hustling and all that stuff. So my kids have no idea about any of that kind of lifestyle, and that's very important to me. I've just tried to be a good father and a good citizen, and I apologize that this has taken place. And you know, even when the officer come to the house to tell me about it, question us about it, even then I wanted to know, how do I pay him? I can't just pay him cash. You know, how do I pay him back to get this over with? And they said, we just have to come to court. So here we are, and I've paid it. Now that I learned how to pay it, I paid it. And, you know, wholeheartedly apologize to Zach for what's taking place, but it was never intentional, never. My wife was her only job was to put it in the filing cabinets. That's it. That's all she knew. All she done is take paperwork and put it in cabinets. That's it. You know, she had no knowledge of anything. And I ran the trucks and was the mechanic full time, and Ron was the administrative. So it just got, I mean, it got overlooked, and I should have stopped and checked it, and I didn't. So I apologize, and just hope you don't destroy my family over a miscommunication.
Well, Mr. Sachs, if your family gets destroyed, it's certainly not my doing, is it?
No, sir. No, sir. It's my fault. It's 110% my fault. I should have paid more attention to what was going on. And I apologize wholeheartedly about that. I was working on trucks and driving trucks, and I honestly just trying to spend time with my family in between time. It was just an overwhelming situation, and I dropped the ball, and I apologize.
Mr. Sachs, the court finds you guilty of theft by deception under $500 and sentences you to 12 months. The court has considered probation or conditional discharge, but is of the opinion that imprisonment is necessary because a disposition of probation would unduly depreciate the seriousness of your crime. You are entitled to 1 day credit toward the service of your 12-month sentence. And I believe restitution has already been paid. Good luck, Mr. Sachs. Court costs are?
$525.
I'll waive those. Are you Mr. Moore, sir?
Yes, sir, I am.
Good afternoon, Mr. Moore.
Good afternoon.
And let's see, Mr. Harper, do you represent Mr. Moore?
I do, Your Honor. Aaron Harper on behalf of Ronald Moore there, Judge.
Okay, thank you. Mr. Harper, have you and Mr. Moore reviewed the PSI?
We have, Your Honor, and the only correction we would note is on page 8 of 13. Mr. Moore's employment with his employer originated in March of 2010, not March of 2020. So he's been employed by the same employer 11 plus years, Judge.
Thank you very much.
Yes, sir.
Do you wish to make a statement on Mr. Moore's behalf?
I would, Your Honor. Primarily would rely upon our written motion for probation exhibits and accompanying order filed on May the 5th, 2021. Mr. Moore is the third of three co-defendants. The court just addressed the two previous co-defendants. Because restitution has been paid, request that he, number one, receive the benefit of the misdemeanor sentence, and number two, humbly request that the court please probate that misdemeanor sentence. Mr. Moore has excelled while he's been out on bond. There's been no bond violations. He's not been arrested on any new offenses. He's worked full-time and the restitution's been paid in full. His most recent criminal record is all the way back 17 years ago, Your Honor. And we submitted what I consider to be some of the most persuasive letters I've ever received from employers. We tendered 3 from his employers there at Millworks. He's a valuable asset, and I know he would very much like to continue his employment there in lieu of being incarcerated, and his employers would like him there. I know the court just addressed the 2 prior co-defendants, and I've reviewed the discovery at length in this case. I discussed this case at length with Mr. Jones, and I've discussed it briefly with Detective Kaufman. And I'm not downplaying Mr. Moore's responsibility in this. My job is to advocate for Mr. Moore, but my review of the evidence reveals that he is the least culpable of these 3. This was an all or nothing deal, and he readily wanted to take advantage of the generous offer of a misdemeanor. But I believe, based on my thorough review of the discovery, that he's the least culpable of these 3. He took active steps to distance himself from Tanker Yangers, and during the relevant period, Samantha Sachs was the secretary of the organization, Judge. That being said, we did reach an agreement with the Commonwealth, just based on everything he's been doing right since this occurred in his gainful employment, and that he's repaid, the restitution has been repaid by all 3 co-defendants. I humbly request that the court please probate him in lieu of 12 months jail.
Thank you, Mr. Harper. Mr. Moore, would you like to make a statement?
Yes, sir. I'd like to just state for the record that I never lied to anybody, never deceived anybody, never took anything from anybody. I found out about this when Mr. Dover informed me of it. He received the letters that the child support was not being paid. That was the first news that I had heard of it. Now, at that point in time, I was already getting out of the company. I had already made an agreement with the Saxes. And if you look in the discovery, you'll see that I have a signed contract with Mr. Sachs saying that he took responsibility for this deal and that he would pay it. I forget the timeline, but he said that he would take it and indemnify me of all harm or losses. Now, I understand that's only financial, not criminal. But now, I told Mr. Dover that the only way that this would ever come to light was for him to press charges. And so I apologize to him and to the court for all this going on. And just ask for leniency.
Well, I don't have the benefit of all the discovery, and I don't have the benefit of the trial to hear exactly what happened. All I know, Mr. Moore, is I have a recitation of the facts as best as could be prepared by probation and parole, and I'm not certainly not having a trial today on the facts. But the fact is, you pled guilty to the felony and misdemeanor if restitution's paid. Restitution's been paid, so you're guilty of a misdemeanor.
Yes, sir.
So you're guilty of the theft. You pled guilty to it.
Yes, sir.
If you weren't guilty, you shouldn't have pled guilty, because how am I supposed to know?
If you don't plead guilty to the plea bargain, you go to trial and lose, you get the max.
Well, that's true. That's a possibility. But
I presented all this evidence to the investigators, the officers. I've been honest with everybody all along the way, and here I am. So trial, to me, seems like it'd be just a waste of the court's time, and actually bad news for me.
Mr. Moore, the court finds you guilty of theft by deception under $500, sentences you to 12 months. I don't know exactly what your involvement was, Mr. Moore. Looking at the facts as presented in the PSI, which is what I have to go on, it does appear that you are less culpable than your two co-defendants, but there's still some culpability there. Of the 12 months, I'm going to order that you spend 5 months or 5 days in jail. You have credit for 1. You have 4 days left to serve. You may do those on the weekend if you wish, or you can do them in one stretch.
I'm sorry, the monitor's breaking up a little bit.
Okay, you've got 4 days you have to serve. You can do those on the weekends if you like, or you can do those in one stretch.
Weekends would be great.
Thank you, Your Honor.
You will report this Friday at 6 p.m. to the jail to serve 2 days.
Okay.
You'll report the next Friday at the jail to serve 2 days.
Yes, sir.
So that'll be the 4 days that you have to serve. But you report on 6 p.m. on Friday, you release 6 p.m. on Sunday.
Okay.
Thank you, Your Honor.
Court costs are,
$175.
when will you pay that?
I can have that paid today, sir.
Okay, I'll show that's going to be paid today. So you report to the jail 6 p.m. on Friday.
6 p.m.
Your Honor, can he actually get into the courthouse today to pay that? I just don't want to set him up for failure.
He cannot. Our phones are already turned off too, Judge. They won't be answering the phones right now.
Could he maybe have just 2 weeks, put that on your 2-week or 4-week out motion hour docket to make sure that that's paid, sir?
Yeah, that's fine, Mr. Harper. That's put it on May the 28th at 10:30 to make sure he's paid it. And Mr. Harper, if you'll just appear and let me know, I'm not going to make Mr. Moore appear.
If it has not been paid.
Yeah, if that's a hassle, yeah.
Yeah, I'll appear if it has not been paid. Yes, sir.
Right. Okay. Good luck, Mr. Moore.
Thank you, sir.
Thank you, Judge. Mr. Moore, we'll talk soon. Judge, that concludes my business, if I can be excused.
Yes, sir.
Thank you.
And I will, for the record, I'll conditionally discharge the remainder of his sentence.
Yes, sir. Thank you.
All right, Jordan Mays.
Sir.
Good afternoon, Mr. Mays. And let's see, Mr. Brown is your attorney.
Yes, Your Honor. Yes, Your Honor. I represent Mr. Mays. I've got the PSI. I have looked at it. I don't see any major errors or omissions. I haven't had a chance to review that with Mr. Mays, but I don't see any omissions or errors in it, Your Honor.
Thank you. Do you wish to make a statement on Mr. Mays' behalf?
I do, Your Honor. Looking at the PSI report, Mr. Mays just come back as a moderate risk. He has a very limited criminal history, Your Honor. This is a possession first degree, first offense case, Your Honor. I've worked with Mr. Mays throughout the pendency of this case. I've known him to be, a hard worker, oftentimes appearing in court from work. I think that he could be a great candidate for probation, Your Honor. If he's given the opportunity, I think he'll I think he'll run with it, and I think he'll do well. He's always been a good client and easy to speak to, Your Honor, and easy to work with. So I think that he'd be a great candidate for probation.
Thank you, Mr. Brown. Mr. Mays, do you wish to make a statement?
Yes, sir. I just recently got a job back at Little Caesars. I work from 5 to 10 every night, Monday through Friday, and Sundays I try to work in the mornings. I'm not trying to break the shift, so I am doing better, and I did get an actual job, so I'm doing better.
Okay, thank you, Mr. Mays. Court finds you guilty of first-degree possession of a controlled substance, methamphetamine, first offense, and sentences you to 18 months. That sentence will be probated for a period of 2 years. Conditions on your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer. Pay your $30 a month supervision fee. If determined, well, let's go ahead and do it. Undergo a drug and/or alcohol assessment. Follow through with any recommended treatment and/or aftercare. Enroll in and successfully complete moral recognition therapy. Random drug screening at your own cost, and you are subject to graduated sanctions by probation and parole. Court costs and public advocate fee are
$545.
$545. Mr. Mays, that is due on November the 12th at 10:30 a.m. If you pay it before then, you don't have to come back to court. If it's not paid in full, that's when I'm going to see you, November the 12th at 10:30.
Yes, sir. I have 2 questions.
Yes,
One,
sir.
when would I be able to get my bond money back so I can pay my restitution?
I don't think you owe restitution, but you do owe court costs. Is the bond money in your name? Did you post it?
It's my money, but my grandmother had brought the money down here. It was my stimulus check, and the money was the card. It's in my name.
Yeah, it'll be probably a week or so before that order is in, before she can get the bond money back.
Yes, sir. And would I be able to sign up for a long-term treatment rehab, probation, parole?
Yes, sir. You talk to them and tell them that's what you need, and they'll help you out with that.
Yes, sir.
And in fact, I need you to go. I don't know. Are they still open over there?
It's 4:14.
No later than tomorrow, Mr. Mays. I need you to go over to probation and parole so that they can get you on their caseload no later than tomorrow.
Yes, sir.
We are open, Your Honor.
They are open? Okay, so you
Yes,
can go
sir.
do it right now, Mr. Mays.
Yes, sir.
Okay, thank you.
Sir, bless.
Good luck. Do we have Sharon K. Hendrickson there? Hendrickson.
How are you today?
Which order did I sign that?
John Stroff, Ms. Hendrickson.
All right, let me get you here. Mr. Straub, have you and Ms. Hendrickson reviewed the PSI?
I have, Your Honor, and I made it available at the front window if she wanted to look at it. She has requested that we file a motion to withdraw her guilty plea. I see that we delivered that, or we submitted it about a week ago. I don't know if it's made it to the court's file yet.
Nope.
I didn't see it on CourtNet, so I guess that may be kind of in the stack of stuff. But I don't know if you want to give that a chance to work its way through or proceed today.
Has Commonwealth seen the motion?
I'm not, Judge. I'm looking for it right now.
It's not even in court yet, Nat. Nat yet.
Would you notice it for this motion hour this Friday, or is it on the 28th?
Let me see if I can pull it up and read it. I have it in my email. I'll pull it back up here real quick. Hendrickson.
Judge, I did get the motion and I put it on for today, but I think I just got it like yesterday or the day before. So I think it's laying on my desk. I'm
Okay.
trying to get it for you.
That's right. That's right. I think I put it on for today. I
Oh, you just
apologize.
noticed it for today?
Yes, sir, because I knew we'd be in court anyways.
The file was already gone, Judge. That's the reason. I should have brought it over this morning.
Mr. Straub, can you email me a copy of it?
Yes, I'll do that right now. We didn't state any grounds, but I'll send it right now.
Okay, so why does she want to withdraw her guilty plea, Mr. Straub?
Your Honor, I really don't understand the reason she has requested it. Would you allow her to speak to that?
Yes, ma'am. Raise your right hand, please. Ms. Hendrickson, you swear affirm the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, sir, I do.
Go ahead, Mr. Straub.
Can I speak?
Oh, okay, I see. What's your name?
Sharon Hendrickson.
Now, Ms. Hendrickson, you have directed us to file a motion to withdraw your plea, correct?
Yes, correct.
And why are you wanting to withdraw your plea?
Because in my motion discovery, it says 0 grams of methamphetamine. That means 0, right? It's in my motion discovery. It doesn't say there was any weight or anything to it, but it said 6 grams of marijuana and paraphernalia. But it said
So
0 grams.
you want to withdraw your
Plea because
you want to
of-
withdraw your plea because you're innocent, correct?
Correct.
Mr. Straub, do you have a copy of the lab report that was sent over?
Let me see. I think this is was this Rocket Docket?
No.
No.
Do you have a copy of it?
I do. I can have it emailed to you. The report states white residue in one glass smoking device, and it tested positive for methamphetamine.
Okay. You can just send that anytime you want.
I didn't get that.
Do you still want to withdraw your plea?
No, I guess not.
Thank you.
Okay, so that motion to withdraw the guilty plea is withdrawn.
Yes, sir.
Yes, sir.
Mr. Straub, did I ask you if there's any correction that needed to be made to the PSI? Did I ask you that? I can't remember.
I think I cut you off before you got there. No corrections, Your Honor.
You wish to make a statement on her behalf?
Yes, sir. She has informed me that she has cancer, and she is waiting on her disability to work its way through. So that's the reason that she's not employed. She has been in touch with a probation officer to get a drug assessment and start her IOP treatment. So she has that in the works, and she is also a big help to her family. She watches a grandchild for her daughter, and she gets her off the school bus, and she really wants to continue doing that. Thank you, Judge.
Thank you, Mr. Straub. Ms. Hendrickson, do you wish to make a statement?
I'm sorry for whatever happened, but my boyfriend tried to take the blame for the pipe because I don't even use a pipe. It wasn't my pipe. I'm the one that went to jail for it.
Well, Ms. Hendrickson, you already told me you knowingly and unlawfully possessed methamphetamine.
Yes, I did.
Okay. You wish to make any other statements?
No, sir. I just want probation so I can be with my family. And I have surgery scheduled for June 7th.
Ms. Hendrickson, the court finds you guilty of first-degree possession of a controlled substance, methamphetamine. On that charge, the court sentences you to 18 months, possession of marijuana, 45 days, and possession of drug paraphernalia, 12 months. These sentences will run concurrent for a total of 18 months consecutive to any other sentence that you might have. Your sentence will be probated for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, comply with the regulations of the Division of Probation and Parole and the directions of your probation officer, pay your $30 a month supervision fee, undergo a drug and/or alcohol assessment, follow through with any recommended treatment or aftercare. I think if you're doing IOP, that's probably a good thing, so that'll certainly count. In addition to the IOP, I want you to enroll in and successfully complete moral recognition therapy. You will be randomly drug screened. You'll have to pay for that. You are subject to graduated sanctions by probation and parole. Court costs and public advocate fee are
$525.
$525. Ms. Hendrickson, that is due on November the 12th at 10:30 a.m. If you pay
I
it,
don't have any means of income, sir. None.
okay.
I
Well,
have
we'll
no
see.
means of income.
You've applied for disability, have you not?
Yes, I have, and I have not, they've denied me 3 times already.
Okay. Have
Been
you,
to the court hearing until,
have you requested a hearing?
yes, I won't get another hearing until January.
May the 13th
Okay.
at 10:30.
And that therapy that you're talking about, would you call that again?
Moral recognition therapy.
More recognition therapy. Okay.
Yes, ma'am.
Right.
Can you read this?
Okay. Ms. Hendrickson, I've just been advised that you were supposed to be assessed with probation and parole already, and you missed the assessment.
No.
So I'm telling you, ma'am, don't, why are you arguing with me? Do you think that's a smart thing to do?
No, sir. She told me to call after court because I told her I had court
Why don't
today.
you let- Ms. Henderson, why don't you let me speak?
Okay.
Terribly
Sorry.
rude to interrupt, and it's stupid to interrupt a judge who's deciding your fate. That's just dumb.
I'm sorry. I'm very sorry.
So if you're going to have that attitude for probation, you're not going to make it on probation. Now, what I was going to say, Ms. Hendrickson, is they think you've missed assessments. Now, if you're not in trouble with me for that, I hadn't probated you then. But if you miss an assessment now, you might be in trouble. So I'd be sure that you do what probation and parole tells you to do.
Yes, sir.
And it's going to take a pretty big effort on your part. And if you've got any kind of attitude with them, you probably need to check it because you probably won't survive probation with an attitude. The attitude that you need to have is contrition. You know what contrition means?
No, sir.
Contrition means I'm sorry for what I did. I will do as best I can to do what I'm supposed to do. That's what contrition means. That's the attitude you need to have. Otherwise, you're not going to make it on probation. All right, so May the 13th, that's when your court costs are due. If you haven't gotten your disability, you'll come to court and tell me you haven't got your disability yet, and I'll work with you on it.
Okay, thank
If
you,
you have
sir.
gotten your disability, I expect it to be paid.
Yes, sir.
Okay. Good luck, Ms. Hendrickson.
Thank you.
Oh, and I need for you to go directly from here over to probation and parole so that they can get you on their caseload. Commonwealth versus Austin Poole. Do we have Mr. Poole there?
Yes, sir.
Good afternoon, Mr. Poole. How are you doing today? Good. Yeah, let's see. Edward, we have Mr. Cooley.
Good afternoon, Your Honor. Edward Cooley for Mr. Poole.
Good afternoon, Mr. Cooley. Have you and Mr. Poole reviewed the PSI?
Yes, we have, Your Honor. We've gone over it in detail.
Are there any corrections that need to be made?
There are, Your Honor, couple. On page 4, let's see, in the criminal history,
Yes, sir.
Guess a couple of corrections and a couple of things of note. With respect to I'll start with about the middle of the page, the 2019 Nashville Police Department resisting stop, that thing. Mr. Poole tells me that he's never been in trouble in Tennessee before. It's only been Illinois and Kentucky, so he doesn't know what the confusion
Okay,
is.
so he denies that that's him?
Yes, Your Honor, he doesn't believe that it could be. So there's that. And then the only other thing as far as correction on this page, further down, November 26, 2020, it shows a Ballard County DUI. Second, we represent him in that matter, and I can tell the court that DUI was dismissed, Your Honor. It was a blood alcohol of 0.02. And then, not by way of correction, but just of note, it's kind of a new thing to me. The very first entry, the LaSalle 2004 alt alarm thing, that occurred when Mr. Poole was 10 years old.
Okay.
And then
I'll make that note.
Yeah, and then 2009, which is the prior felony, That was in Illinois Youth Center. I make note that Mr. Poole would have been 16 years old at that time. And he doesn't understand the entry of 14 years. Of course, we don't have the records, but Austin tells me he got 1 year probation on that in the Illinois youth matter. He doesn't know why it says 14 years prison, but.
Okay, thank you.
Those are the only corrections with respect to that. And the only other correction is on page 8, just the comments, recommendations. It states that the Commonwealth has recommended a total sentence of 18 months, but in this case, it was actually 12 months or 1 year, Your Honor.
Right. Yeah, I
Those
see
are
that.
the
Thank
only
you.
corrections that I had.
Thank you, Mr. Cooley. You wish to make a statement on Mr. Poole's?
Yes, if I may, Your Honor. Mr. Poole is going to ask the court for the privilege of presumptive probation on the possession of meth charge. I can say that for Austin's good points, he's 27 years old. He has his GED. He has a good job. Apparently, he's well employed and good at it. He has 3 children that he supports, has relationships with them. His boss, I don't know if the court got this. I haven't got it, I think, yesterday morning. I filed it this morning, but to paraphrase his boss, John Wilson, sent an email, just to paraphrase. He said he's Austin's boss. He comments that Austin's a very good person. He observes him to be a family-oriented man who loves his children very much, goes out of his way to help his friends and family whenever they need. He believes that Austin made a mistake, and given the opportunity, Austin would convince the court and prove that he's a good model citizen and would never make the same mistake again. So that's from his boss, which is a strong statement. I can say in dealing with Austin over the past several months that when we were speaking, the conversation does often turn to his children. They range in age from less than 1 to 6 years old. So it's consistent with what I've observed with Austin. He has, in looking at his history, I see no violent crimes or no narcotics and those kinds of things, no previous meth. There seems to be some alcohol involved in everything that he's been with, and I see a marijuana charge or 2. But again, the last charge, he's got another DUI he's not been convicted of that yet. That's still pending. So given all of that, he probably would benefit from maybe the supervision and help of the probation and parole folks as far as his assessment. It's a mostly moderate assessment, with the high being on family and social support. His father does live there in the area, and he is close with his father, as I understand it. So given all that, Your Honor, and being a first offense of possession of meth, amphetamine case, we'd ask that Austin be given the benefit of parole.
Thank you very much.
Probation.
Thank you, Mr. Cooley. Mr. Poole, would you like to make a statement?
Yes, sir. I understand I made a mistake. I myself 100% understand that, but if I could get some leniency to continue working hard, taking care of my family, I'd appreciate it.
Mr. Poole, the court does find you guilty of first-degree possession of a controlled substance, methamphetamine, first offense, and sentences you to 1 year, which is consistent with your agreement with the Commonwealth. Your sentence will be probated for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer, pay your $30 a month supervision fee, undergo a drug and/or alcohol assessment, follow through with any recommended treatment and/or aftercare, enroll in and successfully complete moral recognition therapy. You will be randomly drug screened while you're on probation, and you are subject to all graduated sanctions by probation and parole. Court costs are?
$175.
Thank you, $175, and that is due on November the 12th at 10:30 a.m. If you'll pay it before then, you don't have to come back to court. If it's not paid in full, I'll see you on November the 12th at 10:30 a.m., Mr. Poole.
All right, thanks, sir.
And I need for you, let's see, it's 4:30 now. I'm not sure what time they close over probation and parole. If you just go tomorrow over there and make sure that you get on their caseload.
All right, thank you.
Okay,
We're
thanks.
open, Your Honor. Actually, we'll get him transferred to Ballard County.
Oh, so you want him to go today?
Yes, please.
Okay. Mr. Poole, go on over there to probation and parole right now, if you will, please. Okay, good luck, sir.
Thank you, Your Honor. That concludes my business, if I may be excused.
Yes, sir, Mr. Cooley.
Thank you. It's been a pleasure.
Commonwealth versus Bradley Lee Stevenson. Afternoon, Mr. Stevenson. See, and Mr. Straub represents you, is that right?
Yes, sir.
All right, Mr. Straub, have you and Mr. Stevenson reviewed the PSI?
I'm sorry, Judge. I'm pulling this up. We have not. I've been in training for the last 2 days, and I normally would try to reach out to people sooner. I did reach out to him a little bit before lunchtime, around 11 o'clock. Went to voicemail. I left his PSI at the front window and emailed him about it. So I can't say that he's reviewed the PSI. I don't know if he wants more time to look at that or if he wants to proceed today.
Mr. Stevenson, you want to go ahead with sentencing today? You've got a right to review the PSI to verify its accuracy.
Go ahead and proceed.
Do you want to go ahead?
Yes.
Okay. All right, Mr. Straub, did you review it?
I did.
Did you find any corrections that needed to be made?
No, sir.
You wish to make a statement on Mr. Stevenson's behalf?
Just that he's cooperated with the process the whole way, and he's I believe we've had email correspondence previously, and I'm sure he's very sorry for what happened, and we just asked for probation.
Mr. Stevenson, do you wish to make a statement?
Yes, I have a really good job I'd like to try to keep. I don't want to do anything to mess that up. I'm sorry, and this will never happen again.
Thank you. Mr. Stevenson, the court finds you guilty of reckless driving. I'll fine you $25. Following another vehicle too closely, I'll fine you $25. First degree possession of a controlled substance, opiates, I'll sentence you to 1 year. License plate not legible, $25 fine. So you've got $75 in fines plus the 1 year jail sentence, or 1 year prison sentence rather. That sentence will be probated for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that you report as directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer. Pay your $30 a month supervision fee. Undergo a drug and/or alcohol assessment, follow through with any recommended treatment and/or aftercare. Enroll in and successfully complete moral recognition therapy. You will be randomly drug screened and you'll have to pay for that. You are subject to graduated sanctions by probation and parole. Court costs, fines, and public advocate fee are
$600.
$600. Mr. Stevenson, that is due on November the 12th at 10:30 a.m. Pay it before that date and time, I won't need to see you back.
Judge?
Yes.
I'm sorry, I thought you were pausing. I'm gonna have to eat some crow here. We actually did talk on the phone. He told me he's working at Dana, and he has 3 kids, and he lives in Dawson Springs, Kentucky. So I realize you probated him, so it still turned out okay, but I don't want to ever misrepresent anything I say. So
Thank you, Mr. Straub. I appreciate the correction. I'm not going to make any corrections to the PSI. I don't think it's necessary. All right, so Mr. Stevenson, please go directly over to the probation and parole office. It's on 6th Street behind the jail, and they'll get you all set up and on their probation rolls over there. Okay, good luck to you, Mr. Stevenson.
Would they be able to change anything to Hopkins County, anywhere closer to home, or would I have to do it?
You're going to have to talk to them about that. I don't have anything. That's Department of Corrections. I don't have anything to do with that.
Right, thank you.
2 years. Commonwealth versus James D. Greer, 20 CR 712.
Good afternoon, sir. Jeremy Ian Smith. I represent Mr. Greer.
Good afternoon, Mr. Smith. How are you doing?
I'm okay, sir.
Have you and Mr. Greer reviewed the PSI?
Yes, we have, sir.
Are there any objections or corrections that need to be made?
No, they're not, sir.
Do you wish to make a statement on Mr. Greer's behalf?
I would like to, sir. In this case, it's possession of a controlled substance presumptively probatable. Now, obviously, it's a second offense because he's already on probation for a first offense. But obviously, it says something about him that probation and parole did not move to revoke him, put a hold on him or anything while this was going on. Probation would not unduly depreciate the seriousness of offense because no one was harmed. The boat was given back. The boat wasn't of a great deal of money. I think this is a situation where if he continues the way he's going, kind of, I would guess you'd say a double stiff probation. He's going to keep being straightened out. I think he needs something like MRT. He's obviously amenable to treatment in the community. As I saw that you got the letter from Journey Pure that I had sent over there today, and that's something he set up. And he has no history of violence, domestic violence, or anything like that. I would just ask that you allow him to use. You essentially sanction him with another round or more probation with conditions you feel are necessary, and that you just allow him to keep going the right way.
Mr. Greer, would you like to make a statement?
Would, Your Honor. First, I'd like to apologize to the court, and secondly, I've turned around quite a bit already, Your Honor. I remarried, I've relocated to get away from the problems in a sense. I bought a home and property on Old Mayfield Road. I'm staying with my sponsor from the Narcotics Anonymous, and I talk to my support help all the time from Journey Pure. I'm still going to do my classes. My employment job is going great. I've got 4 crews working out here at Exit 11. We're just now started putting up 16 duplexes up there. That's a big project, and we're building a concrete plant and a window plant in Mayfield. So I've got a lot on my plate for that, and I'm trying to keep that, keep me busy, occupied, and just start my life over with my new wife and try to change things. I've like I say, relocated and changed my plans, my numbers, and everything. So I'm trying to do what I have to do. I realize I made mistakes, and I'm trying to take care of it.
Mr. Greer, the court finds you guilty of possession of drug paraphernalia, sentences you to 12 months, first-degree possession of controlled substance methamphetamine, 18 months, and receiving stolen property under $500, 12 months. Those sentences run concurrent for a total of 18 months. Of that 18 months, the court will order that you serve 10 days in jail with credit for 2. You owe 8 more days in jail. The balance will be probated for a period of 2 years. Conditions on your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer, that you pay your $30 a month supervision fee, undergo a drug and/or alcohol assessment, follow through with any recommended treatment or aftercare, and probably if you're doing the IOP at Journey Pure, I'm sure that would satisfy that requirement. In addition to that, I would like you to enroll in and successfully complete more recognition therapy. You will be randomly drug screened. You'll have to pay for that. You are subject to graduated sanctions by probation and parole. Now, from the Commonwealth, I didn't see any restitution is owed in this case. Is that correct?
No, I paid everything up, Your Honor. I still have 2 bonds on this too, but I mean, so whatever fines.
That's correct, Judge.
Okay, I was talking to the Commonwealth, Mr. Greer, but thank
Oh,
you.
I'm sorry.
That's all right. And I also didn't see a victim's impact statement. Was there one? Was the victim contacted?
They were, Judge. Once again, we contacted them via phone and via letter and received no answer and nothing returned.
Okay, very good. All right, so Mr. Greer, you owe 8 days. I would allow you to do that on the weekend.
Okay.
Would you like to serve those on the weekends, or would you like to serve it straight through?
I'd like to do it on the weekend, Your Honor, so I can work.
All right, so you'll report on Friday at 6 p.m. to serve 2 days, and you'll report every Friday after that to serve 2 days until your sentence is complete. Looks like 4 consecutive weekends.
Yes, sir.
And then that portion of your sentence will be complete. Then you'll be on your probation for the next 2 years. And I went over those conditions with you. Court costs are?
$175.
Okay, Mr. Greer, the $175 is due on November the 12th at 10:30 a.m. If you'll pay it before that date, you don't have to come back to court. If it's not paid in full, I'll need to see you November the 12th at 10:30.
Yes, sir.
Okay, good luck, Mr. Greer.
Thank you, Judge.
Yes, sir, Mr. Smith. Commonwealth versus Leah Poole. 20 CR 766. And let's see, Mr. Straub, you represent Ms. Poole.
Yes, sir.
Anything that needed correcting on the PSI?
No, sir.
All right, you wish to make a statement on Ms. Poole's behalf?
Yes, sir. She has, we are asking for probation today. She has filed for disability as a result of various mental and physical disabilities that she has. Specifically with her back, she has fractured a vertebrae in her back, which has caused her nerve damage and a great deal of pain. They're not even able to do surgery on her right now, even though she needs it, because she has a degenerative disc disease, which is going to continue to make her back worse. And she's only 41 years old. She's really bone on her vertebrae, she says. This has really limited her ability to work, stand, bend, twist, and so forth. She has lifting restrictions. Even though she still has these restrictions, she is still trying to help out her family. She takes care of her mother-in-law. So she's a big help to her mother-in-law. She would like to be able to continue doing that. She plans on using her family support to help maintain her sobriety. And she's really stopped being around people who were bad influences on her. And she's told me that she goes to meetings for sobriety, and she is going to soon be starting back up her counseling at Four Rivers. She had previously done counseling, and she's not doing it now, but she had previously done it, and she thought it was helpful. But she plans on going back over there and additionally trying to get back on some medication she is on medication for her mental health issues. So she's got a good plan going forward, Your Honor, and we're asking for probation.
Okay. Now, Ms. Poole had applied for drug court. Ms. Poole, did you want to you want drug court?
Honestly, sir, I would rather not do drug court because, well, like I said, with taking care of my mother-in-law, if I became active in drug court, the woman, I can't remember, Crystal, she done told me that taking care of my mother-in-law is not appropriate or.
Well, it's not a priority. It's not inappropriate, but it's not a
acceptable
priority.
employment, and with everything that I would have to do for drug court, it wouldn't leave me enough time to actually help with my mother-in-law because
My understanding is you were concerned about working or volunteering because of your back. Plus, I think you were having a transportation issue and you live in the county. Is that right?
yes, sir. I live on the outside, on the south side, right over the flood wall. And with my license being suspended, and then after I get convicted of this, they're gonna be suspended even longer. It's gonna make.
All right. It's apparent, Ms. Poole, the drug courts, it's not a good fit for you. So I'm going to deny you entry to the drug court.
Thank you, sir.
One thing that you need to be concerned about is apparently you have a fiance now, but you also have a husband.
I am working on a divorce. I've been trying to get a divorce for 11 years.
Right.
I don't know where he is.
Don't get married if you're still married, because that's a felony.
Yes, sir. I won't.
Don't do that. All right. Ms. Poole, did you want to say anything else?
I also wanted to say, that this charge was complete stupidity on my part. And I'm so completely and totally sorry for that. I mean, there's no excuse for my behavior, and I have took measures to make sure that I don't go around the temptations anymore. I quit running with everybody pretty much, but even on Facebook, I blocked everybody. I've changed my phone number. I don't put myself in temptationist situations.
Well, that's smart, Ms. Poole. All right, Ms. Poole, the court finds you guilty of operating on a suspended license. I'll sentence you to 90 days on that charge. First degree possession of a controlled substance, methamphetamine, second or greater offense, I'll sentence you to 18 months. Your sentences will run concurrent for a total of 18 months. Of course, it'd be consecutive to any other sentence that you might have. I'm going to probate your sentence for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directions of your probation officer. Pay your $30 a month supervision fee. Undergo a drug and/or alcohol assessment, follow through with any recommended treatment and/or aftercare. Enroll in and successfully complete moral recognition therapy. Random drug screening at your own cost. You're subject to graduated sanctions by probation and parole. Now, Ms. Poole, I probated you before.
Yes, sir.
And you haven't done very well. So what's different this time around?
My attitude, for one.
Okay. Well, it's going to take a pretty big effort and probably some pain on your part. Not physical pain, but emotional pain to get through this. But I'd sure like to see you succeed.
Yes, sir.
Because of your past, Ms. Poole, I'm probably not going to be giving you all the breaks that somebody else would get for a first time around. This is what, third or fourth time around or something?
Something like that.
At least, I think you've had at least a couple of cases you've been probated on prior.
Yeah.
Okay, so we need to make it work this time. And that's up to you. We're going to give you the tools to do it, but you gotta walk the walk.
Yes, sir. And I learned a lot when you set me down, so.
All right, Ms. Poole, court costs and public defender fees are
$525.
$525. Those are due on November the 12th at 10:30 a.m.
Okay. Hopefully my disability be started by then.
If it's not, come to court, ask for more time, tell me your disability hadn't started, you're not able to work, and I'll work with you.
Yes, sir.
Good luck, Ms. Poole.
Thank you. Do I need to check in today or tomorrow?
Ms. Atherton, are you still online?
Yes, Your Honor, we're still here.
Okay, so go over to probation and parole right now so you can get on their caseload.
Yes, sir.
Thank you.
Thank you.
Commonwealth, Travis James Austin.
Your Honor, may I be excused, please?
Yes, Mr. Straub.
Thank you.
How you doing, Mr. Kitchens?
Fine, thank you. Mr. Austin, how are you?
I'm doing fine.
All right, let's see, Mr. Johnson is your attorney.
Yes, sir.
Yes,
Mr. Johnson, are there any corrections that need to be made to the PSI?
do not believe so.
Do you wish to make a statement on Mr. Austin's behalf?
Well, yes, he's asking for presumptive probation. He had served 128 days before bonding out. And I wanted him to update you on what's been going on in his life after getting out on bond, as far as work or doing any looking into any drug treatment or anything like that.
Yes, sir.
Me?
Yeah.
Yes, sir. I've got my certificate here. I graduated the Fuller Center. That was my bond condition, but I wanted to further it. I didn't feel like it was working. Going to work. So I'm in Center Point now, Your Honor. 6 months program. I've been there for a month. I took 5 days to go home between Fuller Center and Center Point so I could see my little girl for a little while. I missed the hell out of her. But I know I've messed up and I've been messing up and I've wanted to change for a while and I'm glad to finally have the opportunity to do it. I'm nervous, Your Honor. I don't know.
Okay. That's fine. You're just talking to me.
Yes, sir. But if I could finish Center Point out to see where that puts me in my life, I'd greatly appreciate it. I've been talking to Sean Sullivan, the probation officer for Center Point. I've talked to him twice so far. Seems like a great guy. I just want to do better, Your Honor. I've got a little girl, and I've between working on the boat and going to jail off and on, I haven't necessarily been there as much, and I miss her, she misses me. I'd like to do better.
Okay, thank you, Mr. Austin.
Yes, sir.
Finds you guilty of first-degree possession of a controlled substance, methamphetamine, second or greater offense, and sentences you to 18 months. Court finds you guilty of possession of drug paraphernalia and sentences you to 12 months. Those are run concurrent for a total of 18 months, consecutive to any other case that you might have. Your sentence will be probated for a period of 2 years. Conditions of your probation are that you continue your good behavior, that you refrain from violating the law in any respect, that your report is directed by your probation officer, that you comply with the regulations of the Division of Probation and Parole and the directives of your probation officer. Pay your $30 a month supervision fee. Complete the program at Center Point.
Yes, sir.
Any recommended treatment that Center Point has for you. Enroll and successfully complete moral recognition therapy. Random drug screening at your own cost. You are subject to graduated sanctions by probation and parole.
Yes, sir.
Court costs and public advocate fee are
$525.
$525. That is due on November. Let's see. Center Point's another. You're going to be another 5 months or so.
Well, yeah, it's from 6 to 9 months. If it goes right, I should be out in October. So, but if not, then I could come explain to you in November why.
Let's just give you till May the 13th of 2022.
Okay.
That's at 10:30.
Okay.
Okay, now, we expect you to remember this date. Nobody's going to hold your hand for you, Mr. Austin. You got to remember that date. If you paid your fines and costs before then, you don't have to come back to court.
All right. Could you give me the date one more time so I could write
Yes, sir. May the 13th, 2022, 10:30 a.m.
All right. Appreciate it, Mr. Kitchens.
Yes, sir. Now, if I need you from here to go directly over to probation and parole so that they can get you on their caseload.
Yes, sir.
It's over on 6th Street, right behind the jail.
Yes, sir.
Good luck.
Have a good one.
You too.
Appreciate it.
All right, do we have Mr. Murphy back?
No, Your Honor, that's going to be everyone that has came into the jail for the law.
Hang on just a second. They were going to bring Mr. Murphy back because apparently he might be under the influence.
Yes, sir.
Ms. Atherton, were they going to bring Mr. Murphy over?
Yes, Your Honor, I believe him and his co-defendant are both on their way over.
Do you know what you did?
No, I have no idea.
No, not him, sorry, the other one.
No, I have no idea.
Probated, awesome. I
it's
just
on-
need the link.
Everything here except for no assessment, just complete point.
Judge, can I ask the case number so I can re-pull the file?
That would be 19 CR 1100.
Thank you, sir.
Do you know how many years?
2 years.
Thank you.
Just verified, Your Honor, they are en route.
Thanks, Ms. Atherton.
Oh, can you say that? Yes, she was on, but. Continue. Thank you.
Thanks.
If you hand me those, I'll date them.
Oh. Yeah, I'll just start signing. You can date him. Thanks. They fail suddenly and without warning.
Your Honor, they actually went to the front of the jail. They're on their way around.
Okay,
Or they
thanks.
went to the Sally Port, sorry.
They're at the front door, sir. We don't have a key to that. We'll have to go out. We'll have to go. They brought them around to the front, like entering off the street.
Yeah.
So I can go down there and tell them we need somebody to cut through and get the key to let them in.
Well, whatever, Daryl.
All right, sir.
Mr. Schultz, are you still online by any chance?
Yes, Judge, I just came back.
Okay, I appreciate that. Thank you. Apparently, I don't know if you were informed of why we're bringing Mr. Murphy back, but I was informed that he's under the influence, so, oh, and we lost him, Mr. Schultz.
I'm still here.
Oh, good. So probably what I'm going to do is set aside the sentencing I just did for Mr. Murphy and continue his sentencing till he's not in, under the influence. I don't think it'd be right to sentence him while he's under the influence.
Yes, Judge. Although I'm sure he's happy with the result and it'll be okay.
Right, that, and I don't know if this is going to change the result any, but he's not going to be happy with what happens between now and then.
Yes, Judge.
Most likely. All right, well, Mr. Murphy, we brought you back here because I was advised that probation, you went over to probation and parole, they determined that you were under the influence of a controlled substance. So technically, I could hold you in contempt for appearing before me under controlled substance. I don't think I'm going to do that. You could be charged with appearing in public and under controlled substance. What I'm going to do, did you want to say something to me, Mr. Murphy?
Yes, sir. You told me to go. I went straight over there. They decided I slurred my words. That probably be some of this. I'm not under anything. I'm trying to do what you told me, and now I've been handcuffed and brought back, sir.
Not trying to step on your toes, Judge, but if possible, I would advise him to not say anything.
Sure, that may be good advice. And from what I was told, Mr. Murphy, you told them over there that you were under the influence of Vyvanse.
Vyvanse, I don't know what that is.
Okay, do we have this probation officer or the probation what did he tell you?
I was scared to death when I came to court. I took a half of they in my career.
Okay, what did he tell you?
He actually had admitted that he had smoked marijuana, didn't give me a date, and then turned around and also told me that he had taken half of the pill right before court.
Okay, well, I'm not going to hold you in contempt, Mr. Murphy. I don't know if they want to charge you with an offense. What I'm going to do is, because I believe that you're under the influence of a controlled substance, I'm going to set aside the sentencing that I just had because you're under the influence. I'm going to revoke your bond at this point because you appeared before me under the influence, and I'm going to reset your sentencing for June the 24th at 9 a.m.
Thank you, sir.
Oh, was co-defendant under the influence as well? Okay, and who's her PSI?
Oh, she had two cases, it must be in the other.
Now, what did Ms. Presley tell you over there?
I attempted a drug screener as well, and she admitted that she used methamphetamine. She couldn't give me a date. She initially couldn't even tell me what today was. So I tried to get her to give me a timeline, and she said, I don't know, maybe yesterday, maybe today, maybe the day before.
She did sign an admission sanction form for the use though, sir.
Okay. Well, and I wondered, because you're acting a little bit slow, Ms. Presley. So I'm going to do the same thing for you that I did for Mr. Murphy. It's not right for you to be sentenced while you're under the influence. I'll set aside the sentencing proceeding that I just completed. I am going to revoke your bond, set your sentencing for June the 24th at 9 a.m.
I'm truly sorry. I really am. I understand. Need help.
Okay, well, we're going to try to get you to help.
I'm here. Thank you. Go to jail. Can I go to jail?
Yes, ma'am.
Vicky, you want me to take this back to the car that you got out of it? Probation.
All right, sir. Any other matters that need to be discussed today?
Huh?
Not from the Commonwealth, Your Honor.
Very well. Court is adjourned. Thank you all very much. Have a good day.
Thank you, Judge.